Okay. Yeah, but I don't. That's the thing. I don't know. Tuesday was Tuesday was Bodie State to do hold on.
Good afternoon.
Hi, Nishna. How are you?
I'm okay, and you?
Fine, just fine. See, you found your way.
Yeah, I don't know what happened to my laptop. I'm on my phone Zoom because I can't connect to the internet, so I'm trying to restart. So I just log into my phone until I get on the laptop.
Okay, that's fine. No problem. No problem.
How are you?
I am fine. Trying to keep up with you youngsters.
No, child. I'm trying to stay safe. You see these new COVID numbers?
Absolutely.
Mm-hmm.
Do not take anything for granted.
Exactly.
This thing does not discriminate. It doesn't care whether you're related, married, in love, divorce, enemies. It doesn't care.
You got it.
So take every precaution.
Thank you. You too. Same to you.
I am definitely doing that as far as possible. I've seen so many people, especially those people over 50, have been, not that that's the only group, but
Trust me, I understand.
Much more likely. I see young people as well, 20-something, 30-something.
Because they're the set who are not social distancing.
Yeah, they feel invincible as usual. That it's not going to happen to them.
Exactly.
Some strange reason.
So where's everyone? Anyone was on the call as yet?
Not yet. I guess folks are just trying to speed into their computers and set up.
Okay.
So we'll give them a few moments to come in and get settled.
Oh, where does rain come from? I don't know. It's raining by me.
It's raining by you as well?
Yeah.
Down here as well, not so much, but it's on the way.
But it was a sunny day. That's why I was surprised at the rain.
It is actually outside, it's clear, but the rain is still coming for some reason from somewhere.
You got it.
Yeah. What part of the country do you live? Northeast, south, or west?
South.
Ah, interesting, because it's up here in the eastern area as well.
Okay.
Yeah, interesting. But I heard that something was happening in Bermuda or some.
Oh wow, I haven't heard about that.
Yeah, that there was some kind of something tropical was moving a day or two ago. So I don't know. Maybe that's something to do with that.
Okay. Once it doesn't develop into a storm, because we cannot take anything else in 2020.
I agree. I don't mind a little storm, like a tropical storm, category 1 even. Maybe even a category 2 a little bit. But once it passes 2, we have a problem.
Yes, and a lot of our islands can no longer take anything.
Hell no.
Providence can't take it either because you notice how flooded the areas are now.
Exactly. It's not yeah, the wind is not a problem for New Providence, it's the flooding.
Yes.
That's the problem. Okay, so in essence, we don't need it at all. Just a little rain will be fine.
You got it.
For sure.
Okay, let's see if this worked. I'm trying to get up on my laptop now. I can see if it worked.
Okay, great.
It's a good thing I have Zoom installed on my phone just in case.
To tell you the truth, it's always good to have a just in case backup.
Yes.
Because these electronic things are unpredictable.
Yeah, they're not loyal at all.
No, not at all. Just when you think they should be kicking in, something contrary happens at
You
the
got
wrong
it.
time. Yeah. Very moody. For sure. I see Joanne. Joanne, are you there?
Hi, can you hear me? Yeah, I'm gonna come off of this and join on my phone too because the video isn't working.
Okay, no problem. That's fine. They're just giving you a chance to settle in anyway.
Okay.
I mean, I hear better on this. I don't know if I could join with both and just don't join with audio on the other one.
I think Joanne is making it that we'll see what happens. These bloody techno stuff.
Okay, let me come off this side of the one now. Oh, okay, it's coming up now. Hold on. You can see right now if I get connected. Okay, join. Meeting password 798.
There you are, Joanne. It worked. Can you hear me?
I can hear you.
Okay. Let me come off. That's better. Okay.
Great. Fantastic. We have 2 initiatives.
Coming off right now off my phone.
Just checking. Okay, Joanne is on as well. Fantastic.
Okay, perfect.
So we'll mosey around a little bit and give the others a few more moments, and then we're going to begin one way or
Or
the other.
the other.
Absolutely. They'll have to play catch up. Yes, thanks for that message, Janishka. Wherever they are.
I know.
Oh, man. So while we're just fanning around, like my grandmother used to say, I know last week we had our little talk about trustee. Anybody remembers?
Trustees?
Yeah, our discussion last week was about trustee one.
I know, but
Yeah, I call when I was a student, I called it P and D to remember. Trustee P and D. That's a clue.
powers and duties.
Yes, powers and duties. Just throwing out some hints there, so that's little things that help you remember this crazy stuff.
Now, what do you suggest with all the reading resources, like how we have to reference it? How do you suggest we? It's so much to memorize. So, are there particular resources that we have to keep in mind? I know, like the Trustee Act and Saunders versus Fortier and stuff like that.
Yeah, I would say just don't try to memorize all that stuff. It'll drive you nuts, and it doesn't help anyway at the end of the day. What to do is just to focus on key things. For example, if you have a particular case that talks about trustee duties, you may want to connect that case to the trustee duty concept. Same thing with powers and appointments and whatever case might be. And then, of course, if you have a case, you don't, whatever you do, don't try to remember all the cases as much as you can, especially what appears to be key ones. And you'll know from your reading and discussions which ones are key, because there's a focus on that. You may just want to pull up the case and look at the opening paragraph and the closing paragraph just to see how that case ties into the concept. But don't try to remember all the details otherwise of the case. That's not the purpose here. Okay. But outside of cases, you just, after you've done your reading, my suggestion is, unless you have a photographic memory and stuff, just stick like automatically. Some people have that going on. Most of us, though, have to do the old-fashioned thing. We have to learn, study, remember, do it again, do it again, do it again. Yes. So my thing would be, make sure you do the reading. You always do the first reading completely, and then go back and pick out the main points in each paragraph or page of the reading that you've done, and kind of write them down. Because I don't know what works for you. Different things work better for different people. I would say write them down and try to summarize the main points on each page, each concept of the material that you're reading. And then once you've done all of that, while you're writing all that crap, the brain is funny. It starts to remember things.
It sticks when you write all of that.
No question. And when you write, don't write like 3 words, but don't write an epistle either. Do you follow?
Correct.
Just write enough so that you could remember what the concept is. If let's say you have trustee duties, 5 things listed, you just, write down the 5 things. If each of the 5 things has an explanation, write a brief note as to what each one means. Keep it simple. Once you've done all the reading first, okay? Don't say, well, I'll just write the notes and take a shortcut. I'm not reading anything. I'm sick of reading, kind of. Don't do that. Read first, because while you're reading, the brain does some funny things as well, even though it doesn't appear that way. Okay? And that's one of the reasons why I have you guys read, because while we're reading in our class sessions and having a lecture, that reading has a strange way of some stuff starts to stick along with the yapping. And then when you start making notes and then you go back and study your notes, if you've done all of that, it's hard not to get through. Some people have been successful every now and then of not getting through. Probably didn't do that too well. If you do those things, it is really, really hard not to be successful in your final thing. Okay? I see Cohen has joined us.
Night.
Good night, Cohen. How are you?
Great, thanks.
Great, great. Are you still single?
Still single.
My. What are you waiting for?
You behaving, Cohen?
Trying to.
Well, trying is better than nothing. That's for sure. All right, so this week, as promised, we'll start with the appointment of trustees that we were all looking for last week that nobody told me about in my group, and then we'll go on to trustee remuneration. Hopefully we'll have time today to get into that. If not, we'll have time next week. But that's the plan for today. Just chit chat about the appointment and then the remuneration.
Okay.
How trustees are paid. Okay. Any questions before we go forward? No. All right, great. Now, as usual, I'd like to introduce you to the lecture with a little internet activity called a YouTube clip, because they tend to say some things that, who is this not coming? I won't be able to join class tonight. Let me see what that is.
Georgette Wallace?
Georgette. So I'm going to get into her grits, like you guys say, and ask her why the hell not. Okay? She wouldn't be expecting that.
No, because I wasn't expecting that.
I know, neither was I. I just thought I'd throw it in. And if she panics, I'll tell her it's the corona thing in the air. Who knows? We don't know what we're doing. Okay, why the hell not? Okay, she'll be like, oh, maybe I should put a smiley face so she doesn't really panic. What the hell kind of lecture is that? Okay, why the hell not? Okay, let's see what happens. All right. So before we get into our lecture about the appointment, I have a nice little clip that I'd like for you guys to see about trustee appointments so that it can warm you up for our discussion. So let's see if I can get this going. Okay, share screen. There you go. Man, I'm getting better at this crazy stuff. Can you guys see it?
Yes.
Wonderful, wonderful. Okay. We have two Joannes.
Remember
Yeah,
her?
one is audio and one is video.
So Joanne, you got it to work.
Yes.
How ingenious. Way to go.
Because on the other call, like everybody's always breaking up and I can't hear and I have to keep it on mute.
That's perfect. Ingenious. I certainly wouldn't have thought about that. Okay, here we go.
But the idea of getting trustees in.
Can you hear it?
Did the volume go up?
Okay.
Can it go higher?
Hang on, let me see.
Let me try my earphone.
This recording is a bit low, I think, anyway. Let me take it up some notches.
Deliberately created.
Is that better?
Trusts created through the will of the set law. Not really thinking so much.
Not better?
About, trust created through operation of law.
Okay,
Though,
let me try take it up to close to maximum so I can blow my speakers while you guys listen. Let's see what happens now.
most of the rules
Better?
operate the same.
It's better on my end.
Willing trustees and unwilling trustees.
Right.
And a lot of the rules operate the same. But what we find is that when you're analyzing, and certainly when you're doing reading on this, in most situations, we're really thinking about the operation of express trusts. There is a distinction between inter vivos and testamentary in some situations, but largely these are express trusts that are set up. I'm not really concerned about the distinction between fixed and discretionary, but express trusts in a general sense. Okay, so we're going to kick off with just by talking about how and where these things sit. One of the key things to note, the most important thing that a trustee must be able to do in order to...
I'm sorry, I just need to give you guys an update in case you haven't seen it. Georgette has a serious toothache, she says.
Wow.
Don't want to groan in on you all. Well, toothaches are a problem. So I should say, glad it's you and not me. No, us.
That's what you gotta say?
Yeah, I'm saying glad it's you and not us. However, if you, yeah, somebody says we'll fill you in, great. However, if you feel froggy, F-R-O-G, do we still say that?
No.
We don't say froggy anymore? Froggy, you may join us on mute and close video. How about that? So she can do, we wouldn't know. Okay, some encouragement that is. All right, let's go. Trustee appointments.
be a trustee. It seems really obvious when I say it, but it's the ability to actually have legal title. You need to be able to deal with property. And so if we think about that, natural persons, in most situations, are going to have the ability to be trustees because they can deal with property.
Okay, so first and foremost, and we'll see it again in our discussions, to be a trustee, you have to have the ability to hold legal title. And usually one of those abilities is you must be of legal age and you must also be of sound mind.
Oh, mine.
Absolutely. All right. So without those things under normal conditions, you cannot be expected to be and should not be a trustee of anything.
And in other situations, such as incorporated societies and corporations, they will have the same ability to hold property. And you may be aware that it's actually quite common in business and in the operation of family trusts and similar sort of arrangements to have a corporate trustee. The Corporations Act allows you to create corporate trustees, and they actually charge a differential fee as well. I think you don't pay as much money for going and setting those things up. Now, you will find in some of the case examples where a company is set up to be a trustee, but it also does other things. Companies are vessels of investment for the carrying on of normal business practice. All right? And if you think about it, that's a little bit different to how trustees are supposed to operate. And so when we're trying to think about these, essentially these requirements of a trustee, yes, they are, they can hold legal title to property, therefore they can be trustees. The idea of appropriateness is something for you guys to think about in terms of the strategy that you'll have in setting these things up. because a non-zero fraction of this room is going to be setting these things up, either for yourself, for family, for friends, or in professional practice. And so it's quite common to have corporate trustees that are set up expressly for the purpose of being a trustee for one trust. You just pay the $500 registration, pay the $150 per annum fee, and it has one job. And there's the advantages, of course, of doing that. What is one massive advantage that companies have over natural people? Companies can't die.
Okay, so just in case you missed it, we did say at some point last week, I think, if you hadn't heard it before, that you can have individual trustees, a person, and as he's attempting to discuss here, a corporate trustee. The great thing about a corporate trustee is that corporations don't die. So if the director of the company dies that is set up for the trust, that's okay. You just appoint another director. If it's an individual trustee and the trustee dies, then you have a bigger problem. Now you still appoint another trustee, but there's a whole lot more involved in getting another individual to be appointed as trustee. Okay? So that's a very important differential to note and to remember.
So while you can go about replacing directors, you can go about going and sometimes making changes to your constitution within limits, companies have this idea of continuity that natural people don't. Okay, and note that you can have incorporated societies under the various state incorporated corporation statutes. So there's sections 21, 25 just say an incorporated society has legal personality. And so does section 124 of the Corporations Act. That's essentially what it is. Are you sui juris? Can you hold property? Yes. That's really the starting point with what you need to do in order to be a trustee.
Remember also, if you have not heard it before, that an individual is also referred to as a natural person for the purposes of trust law and administration and otherwise. And the corporation or company is referred to as a legal person. Okay? Another nugget to remember.
All right, and quite helpfully, they've defined that as well in the Trust Act itself. There you go. And so the idea is that, yes, you can have a trustee corporation, so it's something set up specifically for that, or you can just have any old company that holds the property. Strategically, if you've got the choice, don't mix and match the two, because the duties of trustees are different from the duties of directors to go and make ordinary business decisions and make ordinary business risks. Trustees are to maintain low risk investments for the benefit of the beneficiaries, for their betterment, maintain the property. So the fact that those duties don't align means that you can run into difficulty when you've got one company trying to essentially wear multiple hats. And that happens with us as natural people. I mean, I'm a trustee and my family trust at the moment. Because me as an individual has business, I will make ordinary business decisions. And some of those things might go badly. And so there's a non-zero chance that I might end up being bankrupt. Now, oddly, maybe not oddly, bankruptcy actually doesn't stop a person from being a trustee. You can be bankrupt and still be a trustee. And that's because there is a specific section of the Bankruptcy Act that says when you go bankrupt, we kind of ignore things that you're holding in trust. But as you could imagine, being a bankrupt is a pretty clear demonstration that you're not very good with money.
Right.
And so the Trust Act itself.
Does anybody in this group not know what bankruptcy is all about? Are we all familiar with bankruptcy?
Yeah, familiar.
Great. Has anybody been bankrupt yet?
Mm-mm.
That's good. You might be bankrupt and not know it. But theoretically, if you have not been declared a bankrupt, then you're okay. Stay away from that.
Give the right, again, for a collection of the other trustees or a named person under the instrument to remove you without needing to go to court. So it's one of those automatic reasons that you can be removed as a trustee. But the starting point is you can carry on. If you are a trustee and you become bankrupt, nothing's going to carry on other than the ability for you to be removed without going to court.
Does anybody know what causes a person to become bankrupt?
I don't know, mismanagement of my funds. I don't know.
Yeah.
Mismanagement to what extent?
Probably spend more than they have or make bad investments.
Yeah, when you get whatever the reason is, whether you're overspending, wasting money on bad investments, whatever the case might be, when the time comes and you cannot pay your creditors, you know who they are?
Mm.
The lenders.
Mhm.
And you can't pay, if you're a borrower and you cannot pay your lenders, their payments when they become due, then you will eventually be declared a bankrupt, or you can go to the courts and seek bankruptcy so that you can be protected by the courts. If you don't get the courts to do it, then the creditors will file a claim in court on their own and have you declared bankrupt. And what happens then is they will then sell off whatever collateral that they have or any assets that you have, pay off any debts that you owe, and if anything is left, they'll give it to you. If anything is left. Because sometimes when we sell off our assets and pay off our debts, we don't get to pay all of it off because the sale of the assets are not enough. So that only makes the situation worse. Okay? So that's just a little information because he spent quite a bit of time talking about a bankrupt should not be a trustee. And that's primarily the reason why. Okay? Now, there are one or two exceptions, but that is not the rule. Generally, if you've been declared a bankrupt, if you cannot prove that it was not your fault, or you were not spendthrift and totally crazy with your finances, then you might still be allowed to be a trustee. But generally, the answer is no.
But no, the same is not true for companies in liquidation. Once a company goes into liquidation, they cannot be a trustee. The property vests in the Commonwealth at that point.
Who knows why a liquidated company cannot be a trustee? Anyone? Why can't a liquidated company not be a trustee?
Because they can't pay their obligations.
Of course, once a company is liquidated, it's similar to bankruptcy, not the same. Similar. Liquidation means all the assets have been sold off and all the debts paid. So if that has happened, then clearly there's no more company. And therefore, a liquidated company can in no way be a trustee. Okay? So if you start off as a great company as a trustee, and then you survive a bankruptcy for some reason, you remain a trustee, but then you go into liquidation for whatever reason, then of course you can no longer be accepted as a trustee. The courts or some other beneficiaries would have to find a new trustee.
And if you have a company and somebody has applied a petition to the court to liquidate that company, you'd be wise, again, the situation comes up for you guys, you'd be wise to go have a meeting and actually move or assign that trustee. The beneficiaries can do that, or if they can't, then they'll have to go through court. And look, one of the themes you'll get from this lecture today is that going to court is awful. It's expensive, it's time consuming, it's got to be done in the Supreme Court. It's not what you want to be doing. If you can sort your own things out, sort your own things out. And the analogy I draw is the self-help remedies in contract law. In contract law, for example, if the doctrine of substantial performance, somebody performs a contract but needs a small amount of money spent to remedy the defect, you just pay them the full amount less the cost of remedy. It's a self-help remedy, so people don't go to court. In trust law, the Act, particularly Section 12 of the Act, just maps out ways for the settlor ahead of time to put in the instrument mechanisms to stop people from needing to go to court and stop that unnecessary expense as a result.
That's a little something for you guys. If you ever come across any legal dispute, including divorce, God forbid, it's always better generally to try to settle out of court. Once the matter goes to court, it becomes complicated and expensive. You don't have to take my word for it. Go into any court and you will discover on your own. But that doesn't mean if your dispute is so great that it doesn't appear as if there's any other way except court that you shouldn't go. You should. However, and just like it is with the trustees, if you can settle out of court, you should always seek to do that.
Okay, infancy. So being a minor, being under the age of majority, which is 18 in Queensland, in fact, it's 18 in all jurisdictions in Australia these days. Infancy does not preclude you from being a trustee, but as a bankruptcy, they can always be removed. It's one of those defined categories that allows them to be substituted for another trustee.
So if you're under 18, somebody could, or you can become a trustee, quote unquote. But in most cases, it will not hold up in a court of law or for any significant period of time going forward. The beneficiaries will find a way to have that minor person removed as a trustee for obvious reasons. So while the law would allow you to do it on paper, in practice, it will hardly, if ever, work. Okay, very important differential.
So infants can be trustees. Again, there's a bit of common sense aspect to this. Would you want a 10-year-old to be a trustee on your family trust? Probably not. The whole point of having trusts is to separate the benefits and burdens of owning property. One of the glaringly obvious ones is that people, young people, very young people, don't have the capacity to make sensible decisions in regards to property, particularly real property. My 9-year-old doesn't know how to pay bills. There's no mechanism for doing that or learning that. Very, very, very hard. So while they can do it, they can also be removed by right. And it's usually not a good idea. Okay, so the appointment, this appointment process is stuff that we've already learned about. That it's the idea of having an instrument for an express trust, usually to be in. We know that strictly speaking, that's not a requirement. You can create a trust orally. There's some evidential problems, and we also know that we can't transfer title to the trustee, which is fundamental in the constitution of the trust. Can't do that for future property, shows as an action, real property, a whole variety of other property rights registration. So as a result, we know that in almost all sorts of situations, we would do this in an instrument. But that idea of this appointment process, that happens when title has passed. We talked about trust of the promise, that idea of the various legal mechanics that happen. If title hasn't passed, the trust has been made, it hasn't passed, strictly speaking, there is no trust at that point. It's not until things have been transferred that something is constituted.
Do you guys agree with that? If a trust is set up, but title to property and other assets are not passed over legally to the trustee, that there is no trust. Are we all agreeing on that?
Yes,
Absolutely.
yes, nothing to hold.
No. And therefore, no trust has been properly constituted. I don't care what any QC or any other lawyer or anybody else tells you. If it's not transferred legally, there's no trust. I don't care how good the paperwork looks. Okay? For sure. Because people try all kinds of different things.
Okay.
That's why you need to learn, understand the basic rules so that if you ever run into them, whether on your job as a trustee working for a trust company or in your own life, that somebody wants you to become an individual trustee. Remember, you could become an individual or natural trustee for anyone. And you can do one or two things. That's why this learning thing is important. For for persons because it doesn't only apply to whether you work in a trust company as a trust officer only. You can be a natural trustee for a family, friend, or enemy. Doesn't matter. And you can become that natural trustee under two conditions. Because of the relationship you have with the person, you can say, I'm feeling generous, I'll be a trustee free of charge, which is the remuneration side we'll talk about later. Or you can say, I'll be a bloody natural trustee, but I'm not doing it for
Free.
absolutely for free. I have to charge you something because there's going to be some level of work involved, paperwork, telephone calls, emails, all this kind of stuff. And I'm too busy and too broke as it is to do anything free, including being a trustee for you. So I'm saying you could make a couple of bucks just from having a fundamental knowledge of this process and becoming a natural trustee for someone one day. It's as simple as that. But without this information, you could pass up an opportunity like that where you can well make a couple hundred, even a couple $1,000 by being a natural trustee. You never know. That's the beauty of education and information. Okay.
Again, as a practical, mechanical series step, $10. I got my friend Rebecca to come to uni about 6 months ago and said, wait, I need you to be the settler on my trust. And she rocks up barefoot, povo, she described it. I bought a coffee and then I said to her, right, now you need to give me $10. She's like, what? $10? $10. You're the settler on my trust. You were going to give me $10. I'm going to take that $10 and put it in the bank. She was very angry with me about that, but that is essentially what happens. It seems silly. It seems like an arbitrary mechanical amount, but if you guys are a settler on the trust, somebody asks you to do this, bring a $10 note, an envelope, put it in. That's all you got to do. Take that and give it. Now, because you guys are aware that being a settlor, you don't need, when you are a settlor, to transfer all of the property. To create a trust, you just need to transfer a small amount. And $10 has been the classic amount for 40 years. Once the trust is created, then property can be moved into it.
Does anybody know, he's saying $10, that's under the British system. Oh, sorry, not British, Australia. Does anybody know what it costs in the Bahamas to constitute a trust before the assets are transferred into the trust? It's not $10. Never heard the amount? $50. Yeah.
No,
Unless they changed it just before COVID, but that has been the bloody COVID. That's been the standard amount to formally constitute a trust, to make it official, and that's before the assets are actually transferred into the trust. Without that registration fee, that $50, the trust is not legally constituted. You have to take that $50, go to the post office, buy a stamp for $50, lick it, and put it on the document. Then it's officially a trust document. Okay? If you don't do that, then it's not officially a trust document. It's not been properly settled in terms of the constitution of the trust. Once you do that, then now you can go ahead and start talking to lawyers and bankers and others about getting the assets transferred officially into the trust.
Truesdale's case, for those that study tax law, will next year, is an anti-avoidance mechanism for whatever reason in the 1960s in Australia to try and stop people from using family trusts. They made a rule that the settlor couldn't be, if the settlor was also going to be the beneficiary or the trustee on the trust, then a punitive tax rate would apply. And the Barwell Court very narrowly construed that and said that they used the word settlor. So if you've got someone else to be the settlor, then that's fine. And so that's what happens. Often accountants pay the $10, create the and so that you literally, if you've gone to pay a solicitor to set up a trust, they will draft the thing for you, put all your names in it, and in fact, you guys would have had that in a first shoot, or I gave you an instrument, an actual trust deed to go through and look. I'll have a little search and replace document substitution thing, put all your details in it, get the $10 note, and you rock up to the bank and deposit it in a new bank account. That is the classic way you go about setting up an express trust. Okay, but make note that the duties of these trustees at this point, again, we're express trust, usually you want to get somebody willing to do it. In the trust through operation of law, though, they're not willing. Last thing they want to do is be a trustee for things for your benefit. And so you need to make note, though, they have the same duties. And particularly, they have the same fiduciary duties to look after the property for the benefit of the beneficiaries.
Interestingly enough, if for some reason you don't want to be a trustee and the matter ends up in court and the court says that you must be a trustee, then you will be referred to as an unwilling trustee, but you will do what the court says. Otherwise, you will be in contempt of court. And if you are an unwilling trustee, as directed by the court, and you do not act the way any other trustee will act, the courts will come after you and make sure you live to regret it. Okay? Just a little information in case somebody gets caught up as being an unwilling trustee for some godforsaken reason.
This slide shouldn't be new knowledge for any of you. It's just the maximum number of trustees. I've talked about this like 7 times. This is just defined in the Act itself. There's no common law rule that says that you have to have 4. But the common law does say decisions of trustees must be unanimous. And the statute says that charitable trusts are by majority. Again, this shouldn't be news to you guys.
Interesting. I don't know if you guys have heard this yet prior to my lectures, but within private express trusts, common law or the normal practice is that there are no more than 4 trustees. Does that mean you can't have 5 or 7 or 10? No, you can have 5 or 7 or 10, but the standard amount is 4 based on historical activity. Doesn't mean it cannot be 5 or 3. With regards to charitable trusts, however, there's no maximum, and that's interesting. So you can have like 7,000 people on the trustees in a charitable trust. All right, just some food for thought.
Okay.
You may also recall when we talked about Oppenheim's case and this need to try and determine what is administratively workable in terms of number of people, but for private trusts, this maximum cap on trustees means that the courts have sort of had natural limits on how wide trusts can be as a result. And that's often used as the example. Tom certainly does it, to say, look, maximum 4 trustees. If 4 people working full time couldn't manage this trust, it's administratively unworkable. Also note that in situations where you've got a corporate trustee, corporations can have stack tons of directors. They can have a lot of people going through and controlling them. They count as one trustee because there's only one entity, but that can offset the difficulties with workability in regards to this particular area. Also note that the Trust Act itself is old. In relative sense, it's older than I am. And so that some aspects of technology have rendered some parts of this act kind of redundant.
Just bear in mind that old that he's talking about, this 1970 Trust Act, that's not ours.
No.
That's the bloody Australians Trustee Act. Our Trustee Act is
1998.
absolutely, it's fairly young, which means it has taken into account a whole lot of things that their act would not have taken into account in.
Particularly to do with things like minutes and communications, and things that we can do simply in terms of electronic transactions. But sort of a lot of the stuff wasn't really available. back in the day. All right. None of the stuff should be news. Hopefully.
Okay, so we'll hold there. We won't talk about the removal of trustees at this point. I just want us to be introduced to the issue of the appointment of trustees, because that's what we're going to be talking about today. Let me just bring up my first screen notes. Okay, can you guys see that?
Yes.
Wonderful. All right, so into our discussion, the chap from Australia gave us his about the general perspective of the appointment of trustees. Of course, we are modern. We have a modern trust legislation. It's far more modern than theirs, but it was nice to see what happened back in the day a little bit. In the UK, the Trustee Act is 1925, which is even older than the Australian Act. And clearly, remember, the Brits settled and colonized Australia as well. So when the Australians decided to set up their Trustee Act in 1973, which is the same year that we became what?
Independent.
Aha. I was hoping to get somebody off guard. That's excellent, which we just celebrated not too long ago. Did you guys watch any of that remotely?
No.
No.
No? Yeah, we weren't really too hot on any independence celebrations.
No.
Many other things were going on. Doggone COVID, man. Who would have thought that would have created such a nightmare? All right, so here we go. Why don't we start? Well, first of all, what are our objectives for this particular unit, appointment of trustees? Now that we've been introduced to it, we'll talk about the how and when. We saw a little bit of that. You can be an individual or corporation. You shouldn't be a bankrupt. You shouldn't be operating a liquidated company, and so on. So the how and when in the appointment of a trustee is the first thing we'll be looking at. What actions should trustees take before they become trustees and get their appointment? What are the requirements of the act regarding the trustee? And then finally, understanding a little bit of the modern trust law in relation to trustees. So that's where we're going to begin today. And we will start. Who's going to be my first victim? Nishka.
Oh, it's the first victim.
You're always the first victim?
Last week I was the first
That
victim.
letter is A.
Okay, doggone it. So I'm going to reverse the bloody thing. We'll start at the bottom this time and start with Joanne. Okay, Joanne, let it rip. Just know that Anishka threw you under the bus. All right,
Okay.
who may be a trustee?
Who may be a trustee? Any individual who is of sound mind and not legally declared a bankrupt may act as a trustee. Additionally, since a trustee must be the legal owner of property, including real property, it is often required that trustees also be of legal age, which is 18 years, particularly in light of the fact that minors cannot hold a legal interest in land.
So now, right off the top, according to Joanne, to be a trustee, a couple of key things have all been mushed up together in that little paragraph, but they're all very important. Can anybody remember what they are without looking? Number one, you have to be what?
Sound mind.
Of sound mind, absolutely. Secondly, you cannot be what?
Bankrupt.
Not bankrupt.
Declared a bankrupt?
Yeah, not declared a bankrupt.
Legally declared. a bankrupt.
Legally declared. Well, welcome to the
What's the
law.
difference?
You would be shocked. See,
Wow.
for the purposes of being a trustee, you could be bankrupt and nobody knows, including you. How about that? Or as long as the courts do not declare you to be bankrupt, then you are able to be a trustee, even if you are. How ironic is that? But that's
Okay.
how technical it is. All right? So you have to be of sound mind, not legally declared bankrupt. Anything else?
Legal age.
Legal age.
Yeah, you must be of legal age, which in some countries are 18, in other countries 21. And then what's the final important thing?
Something else?
Yeah, something else. Can you believe that? Am I the only one saying there's something else?
You must be the legal owner of
Yeah, of course.
of
You
the
must
property.
be, of course, because if you're going to be the settlor, you can't settle property that's not yours. Nor can you settle property that is not legally yours. How about that? Okay, so those are 4 key issues. All right, keep going, Joanne.
Due to the nature of the duties and responsibilities of a trustee, it is highly recommended that a trustee also possess a high level of integrity, trustworthiness, commercial awareness, and due skill and care.
Mm-hmm.
A corporation may also act as trustee or co-trustees with another individual or corporation. As mentioned previously, a corporation wishing to act as a professional trustee in the Bahamas must obtain a restricted license or a non-restricted license from the Central Bank of the Bahamas.
Yes.
Professional trustees are often held to a higher legal standard of duty, care, and skill than individual or personal trustees, since they represent themselves as possessing certain specialized knowledge and skills in trust administration.
What's another name for individual trustee?
Natural.
person.
Natural persons.
Natural
And
person.
another name for corporate trustees?
Legal person.
Legal persons. Okay, keep going.
Whether a trustee is an individual or corporation, it is important to note that the duties and responsibilities of a trustee are very onerous and
What does
time
onerous, sorry, what does onerous mean? Anyone?
detailed, tedious.
Yeah, tedious,
Something.
a huge burden, absolutely. Okay, keep going.
Very onerous and time consuming and require the full attention, skill, and care of the trustee in the administration of the trust. Notwithstanding the fact that trustees may insure themselves against liability, except a breach of trust from the trust fund under Section 23 of the Trustee Act 1998.
Now I need to say this while it's warm. Trustees have a huge responsibility. Remember, it's been described as onerous and time consuming, which means that a lot of things are going on legally, from the legal perspective, financial perspective, accounting, investments, all kinds of issues. And the persons who are always watching trustees are people called beneficiaries, because they're always looking to make sure that they don't get anything less to it than what they're entitled to. They're always looking to make sure trustees don't get anything more than they're entitled to. Because everybody knows that beneficiaries sometimes try to get more than they're entitled to, and trustees try to get stuff that they're not entitled to either. Many trustees have been found guilty of misusing trust property that is not legally theirs and benefiting and profiting from their position as trustees. These are all no-no. As a result of this, the issue of insurance comes up. So the trustee, because beneficiaries are always looking to sue them, right or wrong, trustees are able to purchase insurance using trust money, not their own money. That's important to know. However, liability insurance does not cover what we call breach of trust. And remember, we may have said in our last discussion, any behavior that is not in conformity with the trust instrument, the Trustee Act, or a directive from the court is considered to be a breach of trust. And therefore, the trustee becomes liable. If the beneficiary wins the case, the trustee will have to pay up out of his own profits. So there's a lot of things going on in the study of trust and administration, and in the real world, even more. This is just academia. And you know, academia only kind of gets you ready for the madness. Take my word for it. In the real world, there's much, much more to each of these paragraphs that we're discussing. Okay? All right, keep going.
The actions and decisions of the trustee are constantly under the scrutiny of the beneficiaries and the protector where applicable, and the potential for breach of trust action is always existent, particularly when there are competing demands from different beneficiaries.
Absolutely. Now, let me just say something about competing demands. Beneficiaries are greedy human beings for the most part who did not work for the benefit that they're getting. That's why we call them beneficiaries. Even though they didn't work for what they're getting, they act as if they worked for it. And so there's always fighting going on between beneficiaries about who's entitled to what, when, and why. Okay, it's an ongoing battle. And so trustees are constantly in the middle of disputes from time to time from beneficiaries who want to question everything that the trustee is doing, rightly or wrongly, to make sure that they can get their way or get their complete benefit. So the battle rages on. All right, keep going, John.
Appointment of trustees. Trustees are normally appointed in the following circumstances: at the creation of a trust, as a substitute for a trustee of an existing trust who has died, retired, or been removed, or as an additional trustee to an existing trust.
So now that's a nice test question. So please just make a note of that. That's the kind of stuff you make your little notes about. What are the circumstances under which a trustee can be appointed? And the answer is 3. For a new trust when it's first started, as a substitute trustee if somebody dies or retires, and then finally as a co-trustee or an additional trustee to an existing trust. That's always something nice to remember for test and real life purposes, okay? But that's kind of an example of the kinds of things that you make notes of and commit to memory for preparation. Okay, keep going.
New trust. The first trustees of a trust are appointed by the settlor in the trust instrument. The settlor inter vivos trust may appoint himself. Sorry?
Oh, the first appointed by settlor in the trust instrument. What comes after instrument?
The
A
settler.
testator.
Oh, testator.
Oh no, I say the settlor,
I say the settler.
Stop the madness.
which can also be a testator, right?
Of course, but that's interesting that, okay.
I'll put a testator on mine.
Yeah, what is fascinating is the 3 conditions under which you can create a trust are the same for everybody. And then when we get to new trust, that second line is suddenly a testator, sorry, a settlor, versus mine, which is
Yeah.
showing testator. Interesting. Okay, keep going.
So this paragraph, obviously,
It's different than your our paragraph is different than this.
this whole section is different. But anyway,
Is the heading new trust?
Yes, the
Yeah.
head of the trust.
but it's longer than yours because you
Stop.
have we have like 3-4 paragraphs, and one paragraph is pretty long. And then we come to yours, appointment of new trustees.
Interesting.
That's
Okay,
different too. But anyway,
can you
do we read yours or mine?
yeah, read my slide. You guys sweat over the extra paragraphs. Make sure
Okay.
make sure for study purposes you read the extras in your sheet. Okay,
Okay.
it'll
Alright.
end up being the same thing, but yeah. But read of my schedule.
Okay. The first trustees of a trust are appointed by the settlor in the trust instrument. A testator may also appoint trustees in his will, inter vivos. In the circumstance where no trustees are appointed, the court may appoint trustees to administer the trust in accordance with the terms of the trust. The trust property will vest in the first trustees of the trust and all subsequent trustees appointed, who will hold it jointly until such time as they die, retire, or are removed.
Okay, so that's your first, setting up of a new trust. The settlor settles or the testator makes an appointment. Does anybody know what inter vivos mean?
While they're alive?
Yeah, during one's lifetime. Very good. Okay. So the appointment is a inter vivos appointment during the lifetime of the testator or settlor. They're basically the same persons. We use the word testator when referring to a will, and we use the word settler when referring to a trust, but the end result is the same. It ends up being a trust in one form or another. All right. So again, if the instrument makes provisions, which it should, we follow the instrument. If the instrument does not make any provisions, then the court will appoint such trustees to administer the trust. That's how it works. Because remember, the courts continue to remain the last resort whenever what? The instrument is silent, the act is silent or insufficient. If those two are not working for you, your final resort is the courts. Okay, something to remember. Okay, keep going.
It is important that trustees disclose any potential or existing conflict of interest prior to their appointment to a trust, as it is a fundamental principle of trust law that a trustee may not place himself in a position where his duty as a trustee conflicts with his personal interest.
Wow. How could that happen, you think? Can anybody think of an example where a person's personal agenda could conflict with his duties as a trustee?
Where they're also a beneficiary? Can they be the same thing? No way.
The trustee cannot be a beneficiary, but the trustee has to make sure that
But
he has no conflict of interest issues.
maybe he's related to the person and thinks he should be entitled to some of the property.
Yeah, that's possible. Maybe he's related to the settlor, or he's related to the one of the beneficiaries. Absolutely. Or one of the beneficiaries might be his bestest girl. See, like, and if that's his bestest girl,
I pay everything to you instead of anybody else.
Yeah, he start favoring her more, especially if it's a what? Discretionary trust.
Yeah.
See my point? So every year he'll give like 25,000 to the rest of the beneficiaries, but for his bestest girl, he might double it to 50,000 in his discretion, which of course would be a conflict of interest for sure. Okay? All right, keep going.
Okay, let's see if we're different. Still different. All properties of a trust vest jointly in all trustees as joint tenants. The power to appoint a trustee is often contained within the provisions of the trust instrument and may be given to a particular person, the trustees or the settler. The trustees or the settler may reserve the power of appointment to himself. Unless the settler reserves the power of appointment to himself in the trust instrument, he no longer has the power or right to retire or remove trustees after the creation of the trust.
Which is interesting because what we're saying here, in some instances in modern trust law, the settlor may reserve the power in the trust instrument to remove a trustee. And some settlers do that, God forbid, so that if a trustee get on their nerves, piss them off or whatever, they don't like what they're doing anymore, they'll simply arrange to have the trustee what?
Removed.
Replaced. Yeah, removed and replaced by somebody else of the settler's choice. Now, that kind of power given to a settler in a trust instrument under modern trust law has a dangerous aspect attached to it, because now the settler gets to exert what? Undue influence. Can he not?
Yes.
In other words, the trustee that he has selected will be living and working every day knowing that if I displease this settler, he has reserved the power of appointment where he can remove me and replace me with somebody else. That will definitely impact on how a trustee will do his work, and very negatively, if I might say. All right, keep going.
A beneficiary who is nominated in the trust instrument to exercise the power of appointment of new trustees may do so, notwithstanding the fact that his beneficial interest may already be disposed, as this specific power of appointment is not conditional upon his beneficial instrument.
Which is another phenomena, folks. Just like the settlor, if the beneficiary is reserved, is given the power in the instrument to appoint trustees, then any beneficiary who is displeased with a particular trustee may move to have him or her removed as well. Okay, So this thing about settlers and beneficiaries having that power to appoint, it is that was not something that was an old common law trust activity. No way. But in modern trust law, we have allowed that to happen within our acts. And so in many cases, settlers and beneficiaries oftentimes have the power of appointment in the trust instrument, which sometimes has a benefit, but all too often is a disadvantage to the proper running of the trust. Okay? Puts the trustee in a very awkward, compromising position. So if the trustee needs to make a hard decision against the settlor or the beneficiary, he may refuse to do it because he doesn't want to be removed. And stop making all that. What? Starts with M. Money. Okay? That's always the bottom line in most cases. All right, keep going.
Okay, beneficiary. No matter
Yes?
the circumstance, all appointments of trustees must be made in accordance with the terms of the trust instrument. The appointment of a new trustee is normally made by a deed of appointment executed by the party, particularly where a new trustee has been appointed to replace a retiring trustee or as an additional trustee to an existing trust.
Yeah, so keep that word in mind, deed of appointment. Know that that is the standard document that we use for appointing a new trustee or replacing a trustee or adding a trustee, okay? You will probably see that again, that word, the term deed of appointment. And then finally, John?
New trustees may be appointed not only by persons nominated in the trust instrument for purpose of appointing new trustees, but also by the surviving or continuing trustees or the personal representatives of the last surviving or continuing trustee by inter vivo.
Inter vivo. You can finish it.
Trust.
Yeah.
Trust only. The personal representative of the last surviving or continuing trustee is not required to exercise the power of appointment and may not be forced to do so.
Thank you very much. You have said a mouthful. I'm glad that you guys have to remember this stuff. But that's why I mentioned once you've done the reading, make notes. For example, let me just take you back to something to show you. Down here, where we have new trustees may be appointed not only by person, may be appointed. Then you see there are 3 different ways that you can be appointed. So in your notes, you want to put new trustees may be appointed. 1, you follow? By nominated persons in the instrument. 2, by whom? Surviving or continuing.
Surviving or continuing
Yeah,
trustees.
and then 3, personal reps of surviving trustees. You follow? So
Yeah.
all of a sudden, you've taken all that stuff and combined it into what? Something that is now manageable to learn when it's time to review. You follow? And so now you don't have to go back to all those words and say, my God, these words, so much stuff to overwhelm me. You already have it mapped out. And during the time that you're writing that stuff, remember I told you the brain is a funny place. It starts to remember things. And then when it's time to go back to review it, by setting it up in that kind of format, it makes it easier to study it and remember it. However, there's no substitute for
Reading.
Absolutely. So don't take any shortcuts. Like I'm tired of reading stuff. All right, thank you, Joanne. Cohen, you were in the middle. Anishka said we picked on her the last time, so she's gonna be after you guys. So why don't you pick up from us with alternatively?
Alternatively, beneficiaries who must be sui juris of the requisite mental and legal capacity and absolutely entitled to the whole of the trust property may also appoint trustees to a trust. In the absence of an express power, Section 42 of the Trustee Act grants the statutory power to appoint trustees. Note that additional trustees may be appointed as long as the total number does not increase beyond 4.
That word, you heard that before, beyond 4? Where did you see
No.
that recently? The word 4, the number 4. from that same little clip. Remember, Tom Jones was saying under with a private trust, normally we would not exceed 4 trustees. Is it
Oh.
illegal to go over?
Oh, yes.
4? Remember that? Yeah.
Yes.
And so we're just kind of reminding you of that here. Also, this little paragraph that you just read is reminding us that, hey, the appointment of a trustee should first start with instructions from the trust instrument. If that doesn't work, then we have the Trustee Act. Okay.
Mhm.
So again, these are the conditions under which we can appoint trustees. Okay, keep going.
In exceptional circumstances, and often as a last resort, the court may appoint a new trustee as a substitute for a trustee that has died, retired, or been removed as an additional trustee to an existing trust, taking into consideration the wishes of the settlor and the potential trustee's impartiality
Yep, impartiality.
and his ability to further the interests of the beneficiaries and the trust generally. Section 48 of the Trustee Act.
Let me just say that. Say this. What Cohen has said is another mouthful, and here's why. That particular chunk of information is an extension of what he just read in the previous paragraph. Remember the previous paragraph says if you're appointing a trustee, go to the instrument first to see what it says. If that doesn't work, go to the Trustee Act of 1998 and see what that says in terms of appointing trustees. And then none of those working, in this last you go to the courts. So if the trustee has died, retired, or been removed, and the instrument and the act does not give directives on what to do specifically, then you take the matter to court. And the court will make the decision as to who will be the replacement trustee. And notice the kinds of things that the court itself will take into consideration. And these things are designed to remind us who are outside of the court of the things to consider when the issue of trustee appointments are being dealt with. For example, what were the wishes of the settlor? That's the first thing the courts will consider. We will consider the appointment of a new trustee now that somebody has died, retired, or been removed. But before we make a decision, we would like to see the letter of wishes. Remember, have you guys heard about the letter of wishes yet?
Letter of wishes, yes.
Yes. Primarily, what is the purpose of the letter of wishes, anyone?
I know it's not a legally binding
Give
document.
some
at best.
guidance.
Yeah, it's not legally binding, but it does indicate what the settler would like and how the settler would like to see his trust operate. Okay.
Okay.
So the settler would say, for example, let's say one of you guys decides to establish a trust. You're going to have a trust instrument drawn up, but your letter of wishes will say this: I want to make sure that my wife, who's been so mean to me, doesn't get more than $10,000 a year. To that child who was negligent, they only get $3,000 a year. To the other one who was kind and gentle towards me, they get $50,000 a year, and so on. Okay? The one who spends money like water, use your discretion. Or give them $1,000 and let them go and squander that. All right? So that's the letter of wishes. Now, that is what how the settler would like to see his assets go to work. Whether or not the trustee will follow that depends on what type of trust it is. If it's a discretionary trust, he may follow it to the letter or not follow it at all. If it's a fixed trust and those requirements in the letter of wishes are in the trust exactly like they are in the letter of wishes, then the trustee will have to follow them to the letter. Okay, so it's all relative to the situation. That is why whenever the courts come in to appoint a new trustee, the first thing they want to see is the settlor's letter of wishes, because that is going to determine the direction they go. The other thing is the new trustee that the court is looking at impartial? What does impartial mean? Does that new trustee have any bias towards any of the beneficiaries? Do they like one more than the other? Were they friends with the settlor? Did they have any romantic relationship with the settlor, personal relation, whatever the case might be that can cause them to be partial or biased? The courts will take all of these things into consideration before it makes a decision. Because remember, the court's interest and duty is to make sure that when a new trustee is appointed, that the new trustee will operate solely in the interest of the beneficiaries and nobody else. Make sense?
Yes.
That's what all of that gobbledygook is about. All right, keep going.
This is done wherever it is expedient, difficult, or impracticable to do so without the assistance of the court. The court will not exercise its powers if an appointment may be made out of court by an express or statutory power.
Now, I'm sorry to interrupt you again, Cohen, but I need to say this. Does anybody remember the difference between express and statutory power? Very important. What is the difference? Or do you think they are the same?
Express would be where someone created the trust. Like
Yes,
and
absolutely.
statutory would be where the court,
No,
no?
not the
Statutory?
court,
Required by law or something.
but exactly right. Who said that?
That's Jones.
Okay, Joanne, go to the head of the class. How did you remember all that crap? Yeah.
Just the meaning of the words.
Yeah, just the meaning of the words. That's the other thing. There are certain key words that can help you to remember stuff. So when it's time to make your notes, just put express, trust instrument, statutory power, trustee act of 1998. See that? And then so when it's time to review, it's like, oh man, I know that. That one's stuck. Okay, and it makes your life a whole lot easier. All right, keep going.
The court will also not interfere if a person has an express or statutory power to appoint new trustees, even if requested by the beneficiaries.
In other words, don't waste the court's time if you have a provision in the instrument or in the act or both. You follow? The courts will tell you, folks, you are wasting the court's time. According to
You have the power to do it.
Absolutely. Thank you very much. According to this trust instrument, you have the bloody power. Get out and go and exercise the power. There you go. Way to go. Okay, keep going.
The case of Shalaram versus Shalaram, 1985, in determining whether the court will act with regard to the appointment and or removal of a trustee, the following considerations were made. 1. The jurisdiction of the court, which was dependent upon the facts in this case.
Yes.
2. The interests and welfare of the beneficiaries. 3. The actions of the trustees. Those trustees who acted improperly or dishonestly and endangered the trust assets could be removed. 4. The nature of the duties to be performed by the trustees and whether such duties were of a particular personal or delicate nature.
So you can see, when the courts finally sit down to deliberate after it is determined that the matter should be before the courts, period, they consider some very key issues, okay? And each and every one of them substantially came towards making the best decision in terms of the appointment, and even in this case, the removal of a trustee. Because sometimes petitions are made to the courts for the removal of trustees as well, not just the appointments. Because some trustees cannot be trusted. Did you know that?
Yeah.
Some trustees have conflict of interest issues where they have to be removed. Some trustees have been found guilty of stealing assets of the trust. Some trustees have been found enjoying the fruits of the assets that of the trust without permission, because they are not allowed to do that. The assets of the trust are for the benefit of beneficiaries only. But some trustees start to forget that their job is only that of trustee, and they try to embellish themselves.
Benefit.
Absolutely, and benefit, sometimes way beyond. But again, I guess that's human nature. And so sometimes when this finally comes to the attention of beneficiaries, they all get together to have those kinds of trustees removed. Okay, keep going.
Alternatively, in Ray Jardine, 1919, LRGB 116, an application was made to the court in Guyana for the appointment of a new trustee.
Does anybody know
Yep.
what Guyana is?
Sorry?
Yes,
Yeah, what part of the world is Guyana?
it's in South America.
Okay. Did anything significant happen in Guyana recently that you're aware of? I know, like, what the hell does that have to do with trust? Nothing, but since they throw Guyana in there, I'm just throwing it out.
What happened in Guyana?
Nope,
You guys didn't hear that they found oil in Guyana?
no.
No.
Yeah. So there's a big thing going on now that they have
Right.
oil.
They'll be rich, so everyone will move.
Imagine if we find oil in the Bahamas, how all hell would break loose, wouldn't it?
Yes.
I think it's probably a good idea that we don't find oil because
Once we all benefit,
we all won't benefit. That's the problem.
That's the problem for Drew.
that should be a constructive trust. What? A
I agree.
resulting trust
I
for
agree.
all Bahamians.
I agree. And unless we get it to the Supreme Court so the Supreme Court can make a ruling and somehow put something in place to enforce that ruling, God, dog eat our lunch. Because as usual, only a small group will rush to benefit. And then the rest of us, as usual, will just nothing. Okay? So yeah, maybe it's a good idea. It'll be great if we find oil, but I don't know. It might be our undoing finally. All right, we have enough problems as it is. All right, keep going.
There were no trustees expressly appointed by the testator, but the three executors of the will were constructive trustee for the estate.
Yes.
The court granted the application on the ground that there were further acts to be completed by the executors, such as protection of the remaindermen against the tenancy for life, then dealing with the remainder during the life tenancy. The three executors of the will were still trustees. However, the court found that they were unfit to act.
All right, that is very interesting. So all of a sudden, these executors who are constructive trustees, constructive by virtue of the fact that they were executors of the will and not directly appointed as trustees, were found to be unfit. And that happens more often than you might think. All right. Let me just remind you, does anybody remember the difference between tenancy and remainderment? Ever heard them before?
No, never heard them before.
Oh, that's not come up yet. A life tenant is a beneficiary who will enjoy the benefits of a trust until they die. We call those beneficiaries life tenants. For example, if a spouse dies and leaves the other spouse in the family home, the life tenancy will be that person stays in the family home until their death. And then upon their death, the home may be dealt with by the remaindermen, however they see fit, whoever the remaindermen are. So the remaindermen are those person or persons who are left after the life tenant has passed on and benefited from completely until their death. Do you follow?
Yes.
Okay, so that is primarily the difference. So why do we need to protect the remaindermen? Well, sometimes life tenants might decide to sell the property, correct? And keep the money, which means that when the life tenant dies, what will remain for the remaindermen?
Nothing.
Zero. See that? So you may not recognize that these kinds of things happen, but they do happen. So for example, let's say you guys have let's say Cohen has a sister, and they say that Cohen's sister can live in the house until she dies, and then after that Cohen can live in until he dies, or he can sell the house and do as he sees fit. If his sister decides to sell the house before she dies, and keep the money, when she dies, what will Cohen have?
No house to live in.
No, and no house to sell. You won't worry so much if you can't live in it, but if you could have it to sell, that might help. And you can go and build another little chicken coop, or rent a condo somewhere and kick back. All right. So these things are very important issues. And anytime trustees are found not doing their jobs with regards to these remainderment in these tenants, life tenants, and so on, they can be the source of much conflict. And in this case, to the extent that the constructive trustees were found to be unfit. Okay, they were executors and therefore constructive trustees, but they were not doing their job properly to protect these two groups of people, beneficiaries. Okay, keep going.
After being appointed to the trust, the trustees are advised to take certain actions to ensure the preservation and protection of the trust assets. The trustee should review the trust instrument to ensure that he is aware of the specific terms of the particular trust and that he is knowledgeable about the provisions in the trust to avoid a potential breach of trust action.
Does that make sense?
Yes.
It does. If you go to the bank for a loan and they tell you read the application and all the conditions of it, should you read it?
Yes.
Good. Most people don't.
Oh, who said that? Or you're so excited about getting that money or that mortgage. So you tell them,
Yeah.
I don't need to read. Fred, where do I
Sign
sign?
anything.
Absolutely. And then we don't worry about Fred until Alice shows up and all hell breaks loose. And then somebody refers you to section 79, subsection 2, subsection 17. Well, and then like, oh my God, why didn't Cohen or Joanne tell me about this? Those crooked loan officers or whatever the case might be. See, absolutely. Okay, and then finally,
Additionally, he should review
oh, sorry. I forgot you were reading on my thingy. Additionally, yeah.
Additionally, he should review and
yes,
inspect the trust documents accompanying the trust instrument, inclusive of the trust accounts, notices, memoranda, trustee minutes, etc.
thank you very much, Cohen, for that mouthful. It was a whole lot of stuff wrapped up into 2 pages of information, but it's crucial information in terms of the appointment and the administration of the trust. And at this point, the whole idea is now that we've finally gotten a trustee appointed after all those things that could impact the appointment of a trustee. Now that you're a trustee and you've been appointed, you must do those things. Read the trust instrument, read the minutes, read the memoranda, read everything, find out what's going on. Don't say, thank God, now I'm interested in the trustee fees. You may not be making them for too long if you don't find out what's going on. All right, thank you very much. And Niska, we finally got to you.
Okay.
Okay, why don't you pick it up? As part
of this inspection, the trustee should confirm that the trust instrument has been properly stamped and validated by the trust duty. Oh, all the trust instruments executed after the 27th of July, 1998 are subject to a trust duty of $50 under Section 92 of the Trustee Act 1998.
There you go. Mm-hmm.
That's what you mentioned, yes.
Absolutely.
In addition to reviewing and inspecting the trust instrument and documents, it is important that the trustee ensure that the trust has been properly constituted by confirming that all legal formalities or requirements have been met to properly transfer trust property from the settlor to the trustee.
Yes.
Whether the transfer of the trust property requires a reconveyance of land, share transfer of shares, change in the ownership of bank accounts, the trustee must ensure, subject to the terms of the trust instrument, that he has legal ownership and control of the trust property as soon as is practical, which is dependent upon the facts in every case.
Okay, so which means that when we're transferring assets, every situation is unique. In some cases, some are similar, some are even the same, but you cannot apply the same process for each client. They all have their own unique situations. So in the case of land, the settlor has to reconvey the land and turn it over to the trustee. Now, why do you think we use the term reconvey?
Does it have to be
It's a
conveyed?
genuine-
Go ahead.
Go ahead, John.
No, you go ahead, Anisha.
Well, Nishka's reading, so Joanne, you go ahead.
Because it's already conveyed to the settler, so he has
Yes,
to reconvey it in the name of the trustee.
absolutely. It's already conveyed to the settler. Now it has to be reconveyed to the trustee in order to effect the legal transfer to the trustee. Once the trustee gets it's conveyed to the trustee, the settler no longer owns it. He can't get up after a drunken spell saying, I made a mistake, please give me my stuff back. It's too late then. The trust has already been established, okay? If there are shares, if the settler has shares, those shares have to be transferred formally on share transfer documents. The settler has to move money off his bank account and put it into the trustee's bank account, okay? So everything must be legally transferred, and whatever documentation to support it must be signed and executed. Okay? So if the settler has to sign a document saying, I have agreed under the trust established on the blah, blah, blah date to transfer $1 million of my cash to the trustee, blah, 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 check number, and so on, then that's what you have to do, get him to sign, and the matter is closed, okay? The point is, failure to execute these things could result in a major, major issue for both parties. Okay, keep going.
The trustee must also ensure that he invests trust funds promptly to minimize the risk of loss to the trust and a potential breach of trust action by the beneficiaries for failing to do so. He must also inspect the trust to ensure that there are no previous breaches of trust which may make him liable as the new trustee. Although he may have obtained a deed of indemnity from the previous trustee, indemnifying him against any previous breaches of trust upon his appointment, he may still risk exposure to a breach of trust action, as some cases have decided that deeds of indemnity may not go far enough in protecting newly appointed trustees, particularly those who fail to discharge their duties promptly and responsibly.
Thank you very much. So there again, the issue of liability, trustee liability comes up and has to do with, yes, the trustee may purchase liability insurance, but the question is, if you're in breach of trust, will that liability insurance protect you? And the answer is hell no, okay? It will not protect the trustee. The trustee will only be protected if he's acting in good faith and is not in breach of the trust, okay? So I think for the moment that ends our discussion on the appointment, quite a loaded discussion just to appoint a bloody trustee. But the reason why it is so loaded is because the appointment of the right trustee, if you haven't figured it out yet, is a very crucial exercise and must be done with due care, skill, and attention. That's why when the time comes to appoint of a trustee for any reason, then we must first go to the trust instrument and say, what does the instrument tell us about appointing a new trustee for any reason? If there's nothing in the instrument, I didn't say if you missed it, overlooked it, your lawyers didn't see it, that doesn't count. If there's nothing in the trust instrument about the appointment, then you go to the Trustee Act of 1998. Scour the whole act and find that section on the appointment of trustees and see what the act tells you can do. If the act does not tell you what you should do, or that sufficiently what you should do, in your opinion, as an existing trustee, for example, or beneficiary, then you are required to go to the courts, and the courts will ask you 2 questions before they begin. Does anybody know what those 2 questions are? Did you consult the?
Trustee.
Yeah, of course. And did you consult the?
Act.
The act. And if the answer to both of those questions is yes, then they are more likely to listen to you. All right, any questions before we move on? Great. Yeah, just quite a bit of stuff for you to churn on. Have fun with that. I'm happy it's you and not me. So now we can
Is
move.
that where your chapter ends?
Because we have quite a lot more stuff for the chapter.
Oh, you have more than that? How many more pages?
But they went to retirement of trustees and removal of trustees, even though the chapter is appointment of trustees.
Oh, interesting. So that's two more paragraphs?
2 more pages.
More pages.
Two more pages? Okay, wonderful. Then that takes me back down to Joanne.
All right.
Joanne, why don't you pick it up with the first page, and then Cohen will read the second page.
Okay.
Then we will go on to remuneration.
Okay.
Okay, let it rip.
Okay. Retirement of trustees. A trustee may retire from the trust in 4 ways. 1, by taking advantage of an express clause in the trust instrument. 2, under section 46 of the Act. 3, by obtaining the consent of all the beneficiaries being sui juris and absolutely entitled to trust property. Or 4, by obtaining the authority of the court.
Now, stick up in a second, Joanne. Interesting is number 2, section 46, is it?
Yeah.
Yes.
Did anybody have the nerve to check section 46?
No.
No.
I know you just read it like, man, the hell with section 46. I have other things to do. I'm stressed about all the stuff to read as it is. I know. Whoever, I didn't script that piece, okay? Because if I had scripted, I wouldn't put section 46. But I think maybe it was designed to maybe force the curious student to go to
Yeah,
section
because I was
46.
like, so what does section 46
Okay.
say?
Well, I'm hoping somebody's in section 46 now by the time I'm done asking about section 46. Does anybody have access to the trust?
Gosh, let me see.
Okay, that's what I thought. Of course, I should say, and to make it easy for you. I want you to go there for the practice. I'm in no rush. Take your time. I have nowhere to go until after 9.
So you tell it. I have to,
Well,
I have to leave
Sarah,
after 9.
I know.
you have what?
I have to go on the road after 9 to be back before 10.
You have to go on the road? What the
Yeah.
hell?
Yeah.
I hope that's an emergency. Suppose something happens, you have to reach home 1 minute after 10.
Once I inside before, once I in the yard before 10, I could be good.
I know, but crap happens along the way.
I pray the grace of God because I can't afford that fine.
I know exactly what you mean, nor the inconvenience.
This isn't coming up. It's taking a while.
That's okay. We have time, Joanne. She's hoping I said, let's just move on.
Yeah.
I could say that, but somebody has to be the devil's advocate.
So these sections, where are they exactly?
And the,
Oh, you found it, Cohen?
I went on Google.
46. Yeah.
You found it in
I'm
Google?
on Google too, but I'm very slow.
Oh, well, section 46, I'm hoping that's referring to the Trustee Act of 1998.
It says retirement of trustee without a new appointment.
Yes.
That's all it says. for
Vesting of
section
trust
46?
property in all continuing trustees. But then I
Thank
went in the
you,
whole
myself.
thing.
Is that section 46?
That's what it says on Google. But when I went into the actual thing,
You mean
it
the
says
act?
something about when a trustee is
I in section 46.
In the act?
The thing is, I have the trustee act saved as a bookmark because of this class, and I just opened it, and I say trustee
There you go.
46, where a trustee is desirous of being discharged from the trust.
Yeah.
Is that the right thing?
Yeah,
Then-
that's what I read too.
Yes.
Okay, finish reading it.
Okay. When a trustee is desirous of being discharged from the trust, then if such trustee, as aforesaid by deed, declares that he is desirous of being discharged from the trust, and if his co-trustees and such other person, if any, as is empowered to appoint trustees by deed, consent to discharge of the trustee and to the vesting in the co-trustees a loan of the trust property. The trustee desirous of being discharged shall be deemed to have retired from the trust and shall by the deed be discharged therefrom under this act without any new trustee being appointed in his place.
Doggone it. Legal mumbo jumbo.
Yes,
So that's section
translation.
46. What I encourage you to do is somewhere along the way,
Oh, God.
summarize that crap in one sentence and put it on side of number 2 and next to section 46.
Well, the summary is, I tell you I want to be discharged. And the summary?
Well, I think I heard them say something about once he gets the okay,
Consent
yeah,
of the other trustees.
exactly, of the co-trustees. That's the key point. And the deed is executed, then he's deemed to be discharged. Okay?
So what is
that's
that, a deed of discharge? That's what it
deed
says?
of discharge, yes.
Okay.
So that is the gist of section 46, number 2. All right. So those are your 4 reasons under which a trustee may be discharged, retired. Okay. The other one that's of key importance, other than the instrument, is the fact that all the beneficiaries have to be in agreement. Not some, not one, not almost all. I think they said all, correct?
Right.
Yeah, consent of all.
Yes, indeed. Okay, keep going.
So it's that difficult to get out of being a trustee?
It is.
Jesus.
You can't just walk out and say, I'm pissed with this thing.
Yes, I'm done.
Yeah,
Yeah,
it's
like-
not that easy. Okay? There's a whole lot involved, and depending on the nature of the trust. Now, if you were an individual natural trustee, just you,
Right.
okay, it would be easier. First of all, you just go with your little itsy bitsy stinky trust instrument, which shouldn't be too long. If it's just you and the trust assets are, like $100,000. So it would not be that difficult, shouldn't be anyway, under those conditions. But again, when it comes to legal stuff, you never know. It could get a little tricky. So yeah, it's not that easy to get out. So be careful how you accept an appointment as a trustee. Know what you're getting into before you sign on the dotted line. All right, keep going.
Take a message. I have to call them now.
Who is reading? Joanna was reading, or Anishka?
Oh, I was reading. Yeah,
Fine.
sorry.
Yeah.
Retirement without replacement. A trustee may retire without replacement where at least 2 individual trustees or a trust company remain to administer the trust. The remaining trustees and any other person empowered to appoint new trustees consent by deed to the retirement, and the trustee executes a deed of retirement. Now, that's section 46 there.
In principle.
Yeah, okay.
Okay. Keep going.
A purported retirement which does not comply with the statutory provision is invalid. See the case of Jasmine Trustees Limited versus Wells and Hines, 2007.
And again, don't be bashful to check the
Case.
key points of the case. You don't have to read it all. You don't have to know it all. Just usually the first paragraph and the last will tell you, okay, this case relates to that particular point that I'm looking for. Okay, keep going.
That's just a question. Is our final
That page?
exam? No. I said just a question.
Sure.
Our final exam, all short answers, essay type?
Mostly essay type, I believe.
Mhm.
All right, I'll see if I can confirm that for you before we're done. But mostly essay questions, which will require you to understand things like what are the steps required to appoint maybe a trustee and retire trustee. How does trustee remuneration work? These are not questions, but it'll be essay questions surrounding these kinds of core issues. So you do want to be able to respond.
Quote some cases.
Yeah, and quote some cases. Don't worry if you don't remember them all. Whatever the ones you don't remember, just say
Just
the
know
devil
like a
with it.
main one for each section or something.
Absolutely, absolutely. 2 or 3 cases for each unit. You follow?
Okay.
Or
Yes.
each main point. And make sure you
A lot of
understand.
cases.
Yeah, because it's a lot. Okay, so grab 2 or 3 key ones and that's it, and apply them to the concept. Unless, of course, you really like feel froggy and like you have this mind that can absorb and remember crap.
No, well, they
Okay,
was in school all day.
yeah. So, and then the other thing is understand the gist of each unit. Like ask
Right.
yourself, what is each unit about? And then write down the main points for that unit. And so any essay question that comes on remuneration and appointment and powers and duties and all that, you're like, okay, bring it on. Because you've already put those each unit in its and made the main points of each unit and studied them until you were sick of it. How's that?
Yeah.
That's what you have to do. So while people are home ducking COVID, you're going to be home studying.
Nobody give you the work.
I know, essential services, unfortunately.
Yeah, that is
We have not gotten a break from COVID
my
I
God.
at
swear.
all.
Yeah, yeah. I'm so sorry. I don't envy you guys at all. Luckily, you're kind of young and think that should help.
No,
All right.
it's not helping. Okay, last paragraph.
Last paragraph, yes.
Retirement under an order of the court. The court may discharge a trustee under Section 48 of the Act only where it is willing to replace the trustee within the power given by the section. And of course, they didn't tell us what the power is.
Of course.
The court,
You have to go to the section that you have bookmarked under the Act of 1998.
the court also has an inherent power to discharge a trustee without a replacement in an action to administer the trust. Re-Chetwynd Settlement 1902.
Mhm.
This may occur where the trustee is not able to retire under the section, or the trustee cannot obtain the requisite consent.
Yes, from the beneficiaries, etc., or co-trustees. Mhm. That's it.
That's it.
Okay, so there you have it. Again, the matter of retirement and replacement of a new trustee ends up finally with the courts after we've exhausted all the other 2 avenues. All right. Any more information on appointment of trustees?
Yes. Removal
Removal
of
of trustees.
Cohen.
Okay, so we'll let Cohen finish that up then.
Removal of the trustees. A trustee may be removed from trusteeship out of court where he remains outside the jurisdiction for a continuous period of 12 months or more, where he refuses to act, or where he is unfit or incapable of acting. He may also be removed and replaced by the court. In addition, the court has an inherent power to remove a trustee without replacement under the principle in Letterstead versus Brewers, 1884.
Mhm.
Which is that a trustee replacement under the which is that a trustee may be removed if his continuance in office would be prejudicial
Yes.
to the due performance of the trust, and so to the interests of the beneficiaries.
Indeed. So
Fraud.
any trustee who's doing crap that is not in the best interest of the beneficiaries and the trust, that is prejudicial to the trust, they have got to go. Mhm.
Yeah. Fraud, bankruptcy, or gross incompetence would be grounds for removal, but it
Indeed.
is not necessary for those seeking the trustee's removal to show misconduct on the part of the trustee. It is sufficient if there is friction between the trustees or beneficiaries or lack of confidence in the trustee.
So you see, you don't have to be a bankrupt, a thief, or a murderer, like my grandma used to say. You can actually just piss off a beneficiary or 2. See? They could stop liking you. They could have a grievance with you. They could have a beef with you. You don't say good morning. You don't call them often enough to discuss their benefit. And so whatever the reason is, they can find some beef. And then if they can get together, they can get rid of you. Okay? Just like an election. If you don't like, they'll vote you out, so to speak. Okay, keep going.
An example was in the case of De Mercado versus City Trust Bahamas Limited, 1986. where under the provisions of the trust deed, the corporate trustee had power to terminate the trust and pay the capital over to the income beneficiaries in equal shares.
Mhm.
The income beneficiaries requested such termination by letter to the trustee, setting out detailed reasons for the request. The trustee rejected the request in a perfunctory manner,
Perfunctory manner, like abrupt, like go to hell kind of way.
perfunctory manner,
Yes.
and after undue delay. The beneficiaries sought the removal of the trustee by the court on the ground that the relationship between the trustee and the beneficiaries was unsatisfactory.
In other
Uh,
words, the beneficiary gave some instructions. The trustee dismissed it, took his own sweet time to respond, pissed the beneficiary off. Like, who the hell do you think you are? You work for us, dude. How the hell you could get to it when you're ready? When we send you stuff as a beneficiary, you are expected to respond immediately. Doesn't matter if you were tied up with something else. Leave that or whatever. That's how some beneficiaries feel. Now, mind you, some trustees have a legitimate reason for a delay in response. But depending on the type of beneficiary, it's like a hen pecking what? You're not married yet, Cohen. So you don't know who a hen pecking wife is. However, if you are curious, you can Google it. But I can assure you, no Google explanation can substitute for the real situation. Okay? All right, keep going.
Georges C.J. said, the principles to be applied in considering the removal of a trustee were discussed in Letterstead versus Brewers. Their lordship stated, in exercising so delicate a jurisdiction as that of removing trustees, their lordships do not venture to lay down any general rule beyond the very broad principle that their main guide must be the welfare of the beneficiaries. Probably it is not possible to lay down any more definite rule in a matter so essentially dependent on details, often to great nicety.
Now, folks, let me just say this. Notice how his lordship puts it. He says this question of removing a trustee is so delicate a matter that we have to kind of revert simply to the basic aspect of how best to do this. And it's always better to start with what the beneficiaries want, see? Because remember, the trust was established for one reason and one reason
Benefit.
alone, for the benefit of?
The beneficiary.
Beneficiary.
Absolutely. So whether you agree with it or not, whatever the beneficiaries say they want within reason, and sometimes even if it's not within reason, as long as not illegal, trustees have to be guided. Because remember, a trustee might refuse a beneficiary on certain grounds, and they might be correct in doing so. But if it's enough to piss a beneficiary off, they can then start action and start getting everybody else together, wrongly so, against the trustee, and he might lose his position as trustee for doing a perfectly legitimate job. Do you follow that? Yeah, it's just like Donald Trump, who did a great job in the last 4 years, but they're trying to vote him out because they don't like him. So it doesn't matter what he did. The fact that they don't like him for whatever known, unknown reasons is the only reason half of the country needs. They don't care that he agreed to make the largest contribution to the Black college, community college in the United States in the history of any presidency. That more Blacks went to work under his administration than any president in the history of and minorities they don't care. Because if somebody doesn't like you, or a group of people don't like you, doesn't matter what you do, they will still seek to get rid of you. Just like Jesus, all that stuff he did, turn water into wine, heal the sick, made the blind, all that stuff. Hey, hallelujah. Oh, Lord have mercy. This guy is an incredible, supernatural person. They did all that. We love you. And then some people got pissed off. And then by the time it was all over, they were beating him half to death and putting him on the cross. Who did he ever hurt? No one. They just had enough people who what? Did not like him. For whatever reason. Doesn't matter what he did. Like, what about all those people he healed? Even raised Lazarus from the dead. What's wrong with you people? Doesn't matter. They still said, give us Barabbas and crucify that doggone whoever you say he is. See what I mean? And nothing has changed. People are still basically that way. All right, keep going. And so it's the same thing with the trustee. No matter how great a trustee you are, if you get on a beneficiary's nerve but they don't like you for some reason, they are going to find a way to get rid of you, and some of them have been successful. Okay? All right. So if you're a trustee, do the best job you can, and that's all you can do. All right, keep going.
All right. Earlier, the lordships had discussed the death of authority in this area and had agreed that in practice, once issues of character had been settled, once it was clear that the continuance of the trustee would be detrimental to the interests of the trust, even if for no other reason than the human infirmity would prevent those beneficially interested from working in harmony with the trustee. The trustee is usually advised by his counsel to resign unless the trust instrument indicated a contrary intention on the part of the settlor.
Now,
In this
folks,
case,
sorry, let me just say this before you go on. All that gobbledygook simply means this. It doesn't matter what the trustees is doing that is good and well, as long as a dispute arises with a beneficiary or two or three or four, then that is the source of the problem, and that could be the trustee's undoing, if for no other reason. Okay? Yeah, very interesting. Unless, of course, the trustee can show other cause in the trust instrument to prevent the courts from getting an aggrieved or group of aggrieved beneficiaries to have a trustee removed. If the trustee's lawyer can find a clause in the trust instrument that says, on this basis in the clause, you cannot remove me, that will override any court's decision or impetus to move forward with such an action. You follow that?
yes,
Okay, keep going.
in this case, there were real allegations of breach and trust and rather direct charge of incompetence. Understandably, these had to be resisted, and I find that they have been disproved. I do find, however, that the charge of unresponsiveness has been made out, and I am satisfied that the relationship between the income beneficiaries and the trustee is such that the interests of the beneficiaries are likely to be affected. The income beneficiaries are both formed the record competent and experienced at managing large assets, and the trust is likely to benefit from close collaboration between themselves and a trustee in whom they have full confidence.
Very interesting.
The trust instrument makes clear that the interests of the income beneficiaries are to be the primary concern of the trustee.
So there you have
Paragraph.
it. In this case, the trustee is done because the instrument itself says clearly that the trustee must work in the interest of the income beneficiaries. So now that precludes any defense that the trustee might have. Okay.
The power vested in the trustee under the foregoing provisions of this article shall be exercised with primary regard for the interests of the income beneficiary of the particular trust, or to the extent the trustee shall deem appropriate. The interests of the members of her family and the interests of any other person shall be disregarded. In the circumstances, although I find that the allegations of incompetence and possible breach of trust have not been
Untreated.
substantiated,
Yes.
I am satisfied that in the interest of the welfare of the beneficiaries, there should be a change. A
My.
more restrictive approach to the court's jurisdiction to remove a trustee was decided in the Bohemian case, Viso versus Chase Manhattan Corporation Limited.
Stop it. Okay. Did they say anything more?
No, that's it. Go read it.
Doggone it. Yeah, go read the bloody case. Uh, uh, I would encourage you to read that first and last paragraph of that Chase case for the simple reason that that particular case takes a more restrictive view of how the final decision was made. In other words, this case with that long oratory by the judge and the court is saying, you know what, the trustee might have a position maybe, but this whole thing's been set up for the benefit of the income beneficiaries, and once they are dissatisfied, even if the dissatisfaction is not completely acceptable, we have to move in that direction. When we check the trust instrument, it appears the trust instrument says that there must be harmony with the income beneficiaries for whatever reason, whether they're qualified to help run the trust and know what's going on. Whatever the reason, the instrument supports the trustees making sure that they keep income beneficiaries happy. That's obviously clearly a liberal approach to the whole deal. That Chase case they're suggesting is a more restrictive one, which means that more than likely when you read that case, you'll find that the response from the courts are not so liberal as it was with this particular case. So that should be interesting to read just for the hell of it. All right. So I think we've beaten the doggone appointment, retirement, removal of trustees to death in one form or another. So we could take a deep breath for a moment and change our focus from that to how the trustee is to be paid for all this stress. It's called trustee remuneration. Okay.
Are we going over the self-assessment questions together?
What I would like for you to do, happy you mentioned it, if you haven't done it yet, go ahead and do the self-assessment questions for last week and the 2 sessions for today, appointment and remuneration. And when we come next week, we'll take a few moments and go through them so that we can see how we're responding.
Okay.
Okay, so that if I don't say anything at the beginning of class next week, just remind me like, hello? Because I might be like you guys, when I look at that, I might not want to be bothered with looking at any response tonight either. Doggone it. But that's the plan for next week. We'll go over the responses for those 3 units, including the one that we're finishing up now, and then we go forward. All right. Okay, so who's our next reader for remuneration?
Second for me, please.
Me.
Anisha. Okay. Cohen
Okay.
is calling for a second. Should we give him a second? Or he's on his own like Pat Bone?
Sure, this is a very short chapter, so he could have a second.
He could have a second and not a second more. Yeah, so while we wait.
I had a comment on the last whole decision of the lordships. Like, is there that's a class they take to write that way? Like,
You mean the legal mumbo jumbo?
yeah, like
Yeah, I don't
that, like
yeah, they need to start.
it's just like never straightforward.
Never. And I think it's that way because it's designed to confuse anyway. Since the law seems to be designed to confuse anyway.
So people could have a loophole.
Yeah, look, there's always a loophole, and lawyers are always looking for a way to exclude the rest.
And they don't ever want to be concrete. Like,
no, hell no.
You know,
they don't want to tie them down to nothing concrete. All right. So that's that old English language of the law, which is long overdue. Okay. They talk about changing from you two to me too. No more boy and girl, there's children with all this modern mumbo jumbo. They need to change that nonsense and start writing in modern English.
Yes.
So that people can understand clearly what they are saying and what they are intending to say. But they love it. It keeps everything confused and confuddled, and that's the way they want it still. So that when they start talking about heretofore and theretofore and hereby and therefore, and you notice in that long paragraph, there's no punctuation.
And it's summarized in the one sentence at the end, like,
yes.
Okay, it should be removed. So why can't you just say that?
Absolutely, absolutely. Instead of running on with all the great nuances and the subtle indelicacies of the prejudicial circumstances surrounding, man, by the time they're done, even they are confused sometimes. What the hell is Cohen? Are confused sometimes. Oh, there he is. Are confused sometimes. All right.
All
So,
right, Nish.
so
Very
now we
good.
have our final discussion about trustee payment, trustee remuneration. What is the law surrounding it? Should they be paid? What happens if they take money and they're not authorized to be paid, and so on? It's a very interesting thing. It is a bone of contention, I might as well tell you, because some people take this thing literally that trustees should not be paid for their work, and some trustees are like, really? If you don't want to pay me, go to hell and find another trustee.
Trustee.
All right, absolutely. Okay, Anishka, why don't you get things started? A trustee may.
A trustee may charge for his services to the trust without being in breach of his fiduciary duty if the trust instrument expressly permits him to do so.
Which means that if it doesn't permit him expressly, then
You can't.
he can't be paid.
Hmm.
Isn't that an egg?
Better examine that before you accept the appointment.
But you can only say that now because you have information as of today. That's when
Mhm.
knowledge is so important, because a lot of people accept stuff and they don't know what the hell they're accepting. It's like getting married. We get married to people we don't really know who the hell we're marrying. Like, who the hell are we marrying? We don't really know. We just look at
You
like the
find
outer.
out very quickly.
Yeah, like she seems nice. She seems rich. She seems sexy. She seems hunky, or whatever we use like on the surface, and then later on, we find out for real who we really married. That is thick thread. Do we still say that?
Yeah.
Thick thread.
Yeah.
Okay, keep going in this.
Amen.
Okay. The charging clauses in trust instruments are strictly constructed by the courts.
Strictly,
Construed by the courts.
which means that
What does that
the
mean?
courts follow the rule of the law normally. In other words, if you go to the courts for payment and there's no provision in the trust instrument, the courts will show you the door. Generally, there are exceptions, but that's the general rule. That's what we mean that by strictly construed. Okay, so you may want to look at Chapel v. White just to see, but that's
Okay.
strictly construed is all about. Okay, keep going.
A trustee must ensure that the trust instrument allows for remuneration before acting as trustee so that his services are adequately considered and duly compensated.
So,
The express,
no, I just wanted to say the key word there that you should underline or highlight is before. Don't sign crap before finding out what you're signing. Okay, keep going.
The express statement of remuneration in a trust instrument is the most optimal way in which the trustees can be assured that his new remuneration is authorized.
Absolutely.
It is even argued that express charging clause in the trust instrument will be allowed even though it may enable a trustee to gain from his fiduciary position, and even though it may produce a conflict of duty and interest. Space Investments Limited versus Canadian Imperial Bank of Commerce Trust Company, Bahamas Limited, 1986, and Sargent versus National Westminster Bank PLC, 1990. Even though there is a charging clause in the trust instrument, the trustee may only charge what is reasonable.
It's my foot. That's a tricky word, isn't it?
Reasonable.
Reasonable, quote unquote.
According to who?
Who's to determine what's reasonable? I have a clip that I want to show you after we do this that attempts, I believe, to try to say something about how to work this reasonable thing out. But we'll see. Okay. But for now, reasonable is a tricky word. Like, what is reasonable? All right, keep going.
A trustee is entitled to recover out-of-pocket expenses from the trust estate if they are legitimate. Such expenses include litigation costs or paying fees to agents. Spike versus Conch. If a trustee takes funds from the trust in excess of what is reasonable, he may be sued by the beneficiaries for breach of trust.
How about that? Doggone it.
The court also has jurisdiction to authorize the payment of remuneration the trustee for past and future services to the trust, notwithstanding the fact that the trustee may have accepted the unpaid office prior to rendering his service. Bainbridge versus Blair, 1845. In exercising its jurisdiction, the court will consider the following information, as in the case of Reed Duke of Norfolk Settlement Trust. 1. The protection against claims of the trustees, particularly in light of the gratuitous nature of the office.
What do we
Two.
mean by gratuitous nature? What does that mean, gratuitous nature? Well, if something is gratis, what is it? Free. Okay? If somebody says, I'm giving this to you gratis, or I'm doing this for you gratis, it means free. Okay?
Okay.
So technically, unless the trust instrument states otherwise, when you become a trustee, that is a gratuitous gesture on your part. But you are technically agreeing to do that work free unless you make provisions prior to taking on that responsibility. All right. Knowledge is held. Keep going.
Number 2, the trust should be well administered and regard should be paid to the nature of the trust, the experience and skill of the particular trustee, the amount which he seeks to charge compared to what other trustees might require to be paid for their services.
Yes, and then, okay, and 3?
Number 3, any other circumstances which may be relevant.
Keep going.
The jurisdiction of the court may be exercised to give a trustee remuneration either for past or future services or to increase the remuneration of a trustee where the level is unacceptably low.
In other words, if you're a trustee and you've been doing a bunch of work for a little bit of money based on an original agreement when you first became a trustee, because things have changed, the decade has changed, the world has changed, the whole 9 yards, you as a trustee can then say, wait a minute, I'm underpaid for all this bloody headache. And you can go to the courts and say, I'm underpaid for this bloody headache. And if the courts agree, they will agree to increase it to a reasonable amount. Okay? And then you probably go back feeling a little happier. If the courts don't agree, dog eat your lunch. And then you can decide if you want to continue as a trustee or not. And then you start digging into the, like, where the provisions for being, then you say, I'm retiring as a trustee. And then you know what that means. Go back to the retirement clause and see what you have to do to retire. And see how easy it'll be for you to retire as a trustee. All right, keep going.
Additionally, as in the case of Reed Keeler Settlements Trust 1981, the court also inherent jurisdiction to permit trustees to keep remuneration they had taken in breach of their fiduciary duty and ordered an inquiry as to future remuneration for some of its trustees.
Okay.
Notwithstanding the fact that such agreements are rare due to allegations of undue influence which may be made against them, trustees may contract with beneficiaries who are sui juris and absolutely entitled for remuneration. Such beneficiaries will be bound by these agreements.
So they can go to, if they don't want to go to the courts first, they can go to the beneficiaries and have a meeting with them and try to make the case. Guys, I think, have I not been a great trustee? I've done everything you've said. I've administered the trust the way that the instrument has suggested I do it. And I'm here for an increase in salary because of the following reasons. If they agree together, all of them have to agree. If one disagrees, you have a problem, Houston. Okay? So it could be as simple as everybody agreeing because they say, yeah, he's a great guy or trustee. Or one might disagree and all of a sudden you're back to square one and then you find yourself having to go to court to try and get the courts to give you the increase. Okay, keep going.
Where trust assets are situated abroad and the law of the country where the property is situated allows trustees to receive remuneration, and the trustees under Bahamian or UK trust receive such remuneration, they will not be bound to account for it unless they went out of their way to obtain it.
Okay, so in other words, if another jurisdiction says it's okay for you to charge and be paid, then that's not a problem. Okay, so for example, if the trust is in the Bahamas but the assets are in the UK, the fee is paid in the UK and goes into a UK account and so on, for the trust that's here, then there is quote unquote not a problem. However, if the assets are here, then you have a problem, right? As a trustee, you now have to go to the beneficiaries and the courts and all that stuff if you want an increase. Okay, keep going.
As a corollary to the remuneration of trustees is the rule in Keach versus Stanford, which states that a trustee must not allow his interests and duties to conflict. Additionally, a trustee is not allowed to take any profits from his position as a trustee unless these profits have been authorized by the trust instrument. The beneficiaries who are Sir Juris or the court, Boardman versus Phipps, 1967. Similarly, a trustee cannot purchase trust property for himself, Tito versus Wadwell, 1977. This is not a duty imposed on trustees, but a disability. Any purchase of trust property by a trustee at the instance of a beneficiary will be voidable no matter how fair, open, or honest the transaction may have been.
Wow. So there you have it. Some very interesting restrictions with regards to remuneration, and part of the restriction has to do with the trustee's ability to purchase trust property for himself. Clearly, that is always a kind of conflict of interest because the trustee is so well knowledgeable about the assets of the trust. He is able to make all kinds of provisions that will be to his benefit, like purchase it for a lower price than the market price and all this kind of stuff. Then if he's able to purchase, then it creates a conflict of interest because now, you know, he's the beneficiary of trust property, and so certain beneficiaries ask him to do stuff they feel he has to do. It's a whole gray area, which is why you shouldn't do it. All right. And notice, even if a beneficiary agrees, it is still voidable because basically the trust process in its entirety does not want the trustee to be a part of that kind of conflict of interest or any other kind for that matter. Okay. So that's some food for thought. So if you decide to be a trustee one day, pull out your notes, read it first, and see if you really want to be a trustee. Okay, for sure. All right. Before we get into my final clip, and then I let you guys go and not be arrested. Can you guys see this thing that I just brought up?
No, that's
Yeah.
no.
Okay. So I need to.
Notes
stop.
is still up.
Yeah, I need to stop share this one. Oh, my notes are still up. Oh, got it. How do I get my notes off?
No, it's off now.
The notes are off?
Yes.
Okay, great. So I can bring up that baby. And okay, share screen. Can you guys see the screen? Can you see this? Okay, great. Now this is not in your notes. This is just some information of interest that I discovered in my foray, just to give you a different perspective outside of your notes. And so you don't necessarily have to get through all of the pieces, but I do want to introduce you to some different perspectives outside of your notes in terms of trustee remuneration. They are interrelated, but they just kind of give you a different view. All right. So Joanne, I think you're next on the reading list.
Oh dear.
Okay. Oh, so I thought I was done for the evening.
I know. Okay.
Are you
let me see
almost
if I
done
can-
though? How's that? Okay. Yeah. Trustee
Okay.
remuneration again.
Trustee, can you hear me?
Absolutely.
Okay. Because my other screen disappeared.
That's okay. And we can hear you and see you.
Trustee remuneration. The world of business has had some new complexities and challenges in recent years, resulting in increased pressure on organizations in terms of governance and compliance. For a trustee, not only has an increased workload resulted, but also the level of responsibility, risk, and complexity. Remuneration for trustees has not been formalized, and a range of practices exist.
So you notice, even though the language is a little more modern than the language of the text that we just discussed, kind of brought us into like the 21st century kind of discussion. The issue of remuneration continues to be one that has not yet been formalized and is still out there under the banner of what? Reasonableness. See my point? All right, so let's go.
The question persists about how one should set trustee remuneration. What factors should we consider? Duties of a trustee.
Factor number one, okay.
The role of a trustee can exist in various entities: a medical aid, a retirement fund, a share scheme, trust, and a trust.
Yes.
Trustee can be considered to be any of a group or board of persons appointed to manage the affairs of an institution or organization. This would include directing the funds and policy of an organization.
Indeed.
A trust can be set up either to benefit particular persons or for any charitable purposes, but not generally for non-charitable purposes. Typical examples are a will trust for the testator's children and family, a pension trust to confer benefits on employees and their families, and a charitable trust.
Now,
In
let me
all
just say this.
cases,
I just kind of throw this in here to broaden your perspective a little bit. We had all that old English thing about, not old, you know what I mean, about trustee remuneration and all that. This is like opening things up. Like this trust thing has all kinds of tenets, like the pension trust, the family trust, the charitable trust, and the list goes on and on. So hopefully it kind of like, you know what, open your mind a little bit that this trust thing is very extensive. Okay.
in all cases, the trustee may be a person or a company, whether or not they are a prospective beneficiary. The term trustee is also applied to someone held to a fiduciary duty similar in some respects to that of a trustee proper.
Absolutely. So let me ask you, are parents trustees? Are parents trustees?
Nowadays, that less.
Yeah, we're a couple of we're trustees and settlers. Are we beneficiaries as well?
Parents?
Yes.
I don't know.
I guess it
Maybe
depends.
in latter days. Right?
Yeah, maybe depending on the kind of children we have.
Yeah.
Absolutely. Because I see some old people on the road, like you wonder if they ever had any children. I already told my children, whatever you do, if you don't want to be bothered with me if I live to get old, just take me to a nice, comfortable, what do you call them? Senior citizen center. Buy me a nice, fluffy bed, shave me, cut my toenails, give me my Netflix thing and some books to read, and be off.
They have to create one of those over here first.
I agree. That's the other problem. That won't happen in my lifetime. So if they don't take me in, I'll just fall off somewhere. But yeah, it depends. Parents are trustees of children when they're little, are not able to take care of themselves. We're constructive trustees. We're settlers because oftentimes some of us have something to leave for our child. If only $10,000 life insurance, that's better than nothing. And certainly if we live long enough, we might be the beneficiary of some kind of gratitude from our children, maybe. That's not guaranteed. All right. But we hope. All right, keep going.
Trustees have certain duties, some of which are fiduciary. These include the duty to carry out the express terms of the trust instrument.
Sounds familiar?
Yes.
Okay.
Defend the trust, prudently invest trust assets,
Uh-huh.
be impartial among beneficiaries,
Mm-hmm.
account for actions and keep beneficiaries informed, be loyal, not delegate, not profit, not be in a conflict of interest position, administer in the best interest of the beneficiary.
Is that clear to every student in the room? As you can see, that is a
Oh,
summary,
gosh.
interestingly enough, of all the, not crap, stuff we've done so far in terms of the duties and powers of the trustee. All right. But notice it has come up as an aspect as to why trustees need to be given consideration for being what? Paid for the work they do. And they do get paid well for the most part, especially professional trustees. Okay.
So I had when it says be impartial among beneficiaries, it
Yes.
goes back to, um, let's say somebody left letters of wishes and the settler feels like one person is entitled to more than someone else. Is that
Yes.
still being impartial?
Well,
Like if it's a discretionary trust, they don't have to pay attention to the letters of wishes.
you mean in terms of the trustee?
Right.
Yeah. Well, being impartial would be trying to follow what the settler says he wants without
Okay.
doing your own thing.
Okay.
Because you
All
don't
right.
think,
That
yeah,
type of impartiality. Okay.
correct. Because the settler
Not
might say
saying everybody has to get the same thing.
correct. Not only that, sometimes the settler might say something that in the letter of wishes that the trustee feels is unfair to certain beneficiaries. And so they might try to change it or not exercise the discretion according to how the settler wanted it to go. Even though you might not agree with the settler's wishes, you have to be impartial and generally follow those wishes. Absolutely. All
Okay.
right. So yeah, if there's a beneficiary you don't like and you have discretion, doesn't matter. You still have to be impartial and fair to that person, even though you don't like them. So you can't say, in my discretion, I'll give everybody 50,000, and I'll give this one I don't like 10,000. That would not be being impartial. You follow? Absolutely. You have to be fair and unbiased. All right, keep going.
The terms of the instrument that create the trust may narrow or expand these duties, but in most instances, they cannot be eliminated completely. A trustee carries a fiduciary responsibility and liability to use the trust assets according to the provisions of the trust instrument, and often regardless of their own or the beneficiary's wishes.
Absolutely.
The trustee may find himself liable to claimants, prospective beneficiaries, or third parties. In the event that a trustee incurs a liability, for example, in litigation or for taxes, or under the terms of a lease, in excess of the trust assets they hold, they may find themselves personally liable for the excess.
Wow. It's
Yeah,
almost like,
wow.
yeah, isn't that spooky? Because that means now if you're a trustee and you are sued and the trust assets are not enough to cover any kind of liability that you may incur as a result of being sued by the beneficiaries or others, then they can move in on your personal assets and sell your house, your car, anything that you have.
I need to go create a trust.
Okay? So, yeah, so be careful. That means that
My
if
assets.
yeah, if you're not, yes, which is what a lot of people are doing. Okay, if you're a natural trustee and you're sued, and the trust assets that you hold that have been turned over to you by your friend, who you acted as trustee for, is not enough to cover the litigation, then they can come after your personal assets. So you have to be careful when you agree to be trustee. There is some liability connected to it, for sure. Okay, keep going.
Trustees are generally held to a prudent person standard in regard to meeting their fiduciary responsibilities through investment, legal, financial, and other. Trustees are generally held to a prudent person standard in regard to meeting their fiduciary responsibilities, though investment, legal, financial, and other professionals can be held to a higher standard commensurate with their higher expertise. Trustees can be paid for their time and trouble in performing their duties only if the trust specifically provides for payment. However, not all trustees are remunerated for their role. As an example, where an employee is acting as a trustee as part of their broader business role, their contribution is seen to be part of their role and therefore already remunerated.
With their
If
own
one,
salary, yes.
if one is to consider the value in the contribution that one is looking for in a trustee, there must surely be a question of how one would differentiate remuneration based on this contribution. As time goes on and as requirements increase, we see a closer alignment between the remuneration of a non-executive and a trustee. The remuneration principles for a large fund trustee and a company non-executive director are similar in that both are independent, are responsible for the direction and strategy of the organization, ensuring that the fund members or shareholders' interests are best served and ensuring good corporate governance. However, the role of a large fund trustee is different to that of a company non-executive in that the breadth of the function of a trustee is narrower, but at the same time deeper from a technical perspective.
My. Thank you very much, Joanne. And in a nutshell, it just means, hey, these two guys operating within a corporation certainly have different roles and different trustee, constructive or otherwise, trusteeship responsibilities. How they're compensated, though, will be a function of whose perspective is being pressed into the functions of these particular persons. So it goes back then to the issue of how should trustees be paid, any kind of trustee. And the real core of the matter is it's all going to depend on the circumstances and the jurisdiction and all these kinds of variables. The key is, if you're a trustee, unless you agree to do it free, you should seek to be remunerated for your service, no matter what kind of trustee you are. Remember, there are all kinds of trustees, okay? From the normal settlement to the pension to the will trust. It's a whole string of the executives within a firm, the non-exec. All these persons are acting in a trustee capacity, and how much you're going to be compensated is going to be a function of how you negotiate your role within your capacity as trustee. All right, thank you, Joanne. We are going to end our reading with Cohen. Cohen, can you start the reading on role factors? And then I'll let you see my short clip, which you must see, and then we'll be done. All right, role factors. Again, role factors is the second reason for this issue of remuneration. The first one, anybody remembers the first one that we just did? First reason for remuneration?
Duties.
Yeah, trustee duties. All that crap you have to do. All that work you have to do. That's all that stuff that Joanne was talking about. That's different kinds of work. Okay, so that's the first thing. All right, Cohen, why don't you kick in with role factors? Second reason why.
Role factors. As in the case with a non-executive director, the remuneration is influenced by the specific individual as well as the organization in which they serve in this role. The following factors could guide the remuneration decision when considering A, the individual, reputation, track record, experience, specific knowledge and skill, industry understanding, network reach, value add, qualifications.
In other words, if you have all this great stuff, you can influence whether or not you will get remunerated and the amount you'll be paid. If you're a young punk chick, you don't know all this stuff too well, that will influence whether you get remunerated at all and how much you get paid. So on an individual level, you can see all the different reasons given to determine whether you get paid and how much. Same as in any other job you do. It's the same if you go for a job somewhere. You and a friend might go for a job somewhere, and when 6 months later you discover your friend is making more than you. And you're wondering, like, how the hell did that happen? We're kind of equally matched. Well, maybe but somewhere along the way, your friend was able to persuade somebody that they should get paid more. And the reasons for that are sometimes known and oftentimes unknown. Okay, but from an academic perspective, from an individual point in A, we can see all the reasons why compensation should be forthcoming. Keep going.
B, the role played, chairperson or committee member, independence of the individual.
Okay,
C, organization trust type, organization size, assets, turnover, sales, number of employees, market capitalization, complexity of work or industry, number of core products or services, structure of the organization, impact on sector, industry, national economy, or international impact.
so in other words, the more sophisticated the trustee job is, the more money you should be expecting to be paid, and God forbid you should even perhaps demand to be paid, because you're going to be held accountable for all these complex issues. You're not going to be liable for trying to remember all this accounting and other marketing mumbo jumbo. I just kind of throw that in you there so that you can see the diversity that could be involved in the trusteeship, and why a particular trustee might be hollering before the courts or otherwise for a certain amount of pay, because this stuff involves a whole lot of work and responsibility and training and experience and a whole bunch of that other individual stuff. Okay, keep going.
When setting trustee pay, one has to consider the individual, the role, and the type of organization. The organization could choose to pay at a higher percentile for an individual who exceeds expectations in terms of the above. The decision would be taken in the context of sound governance principles and affordability.
We hope. Keep going.
Ideally, a general agreement should be reached regarding the organization's market position related to pay. More specifically, the organization would need to agree and confirm the percentile at which to pay. As we see more formality in this area of business into the future, it means that a market would automatically be created and a new benchmark will be set for trustee remuneration. In other words, as more individuals receive payment, more data will be available and will start to influence pay for this role.
Indeed, just like all the other jobs, you guys, whatever jobs you do, there's a market trend somewhere, there's a history somewhere pertaining to salaries, and that's how salaries are set. And a lot of times, if you, let's say you go from one industry to the next, how you're paid is oftentimes a function of some of these things we're talking about and what's going on in the industry for persons who are paid for the job that you're doing. So again, the trust remuneration side is just catching up with what we've always been doing in industry for other types of jobs. You follow? And that's really what we're saying here. Because remember, for centuries, trustee work was done what? Free. And then when professional trustees came on, they said, hell no, we're not doing it free. We have a bunch of trained professionals to pay who have liability and all this kind of stuff. We expect to be paid well enough to cover all that stress. And so now trustees are being paid far better than they used to be back in the day, and even establishing market trends for remuneration going forward. Okay, keep going.
One would consider the good corporate governance and best practice principles in order to ensure that the remuneration of the trustees is transparent, fair, reasonable, and satisfactory. Consideration should be given to the following. Trustee level. All trustees have the same level of responsibility regardless of experience and expertise, as the risk, accountability, potential liability, and responsibilities are the same.
So if they're the same, generally the pay will be what?
The same.
Generally, yes, that's the point.
Employee trustees. Trustees who are full-time employees are generally elected or appointed and are paid by their employers. The principle behind remunerating them is primarily in order to reimburse their employer for their time away from their official duties on fund business. To this end, as a general rule, employee trustee remuneration is paid to the employer. This means that as far as the individual employee trustee is concerned, they are not paid for being a trustee as they are already being paid by the employer.
Do you get that,
Independent,
Charles? Does that make sense?
yes.
Yeah, so if you're a trustee for your company you work for, you're already on salary and you're doing work on behalf of the company, you're not going to get a separate pay and you shouldn't expect it unless they agree to it for some reason. All right?
Mhm.
And again, all these things we're looking at now is just to kind of help you to measure how to establish the, remember that reasonableness we talked about? These are just now portrayals of how to establish some degree of reasonableness when it comes to trustee pay. Okay.
Independent trustees. Independent trustees are generally fee-earning professionals in the private sector. The principle behind remunerating them is primarily in order to ensure that expert skills and knowledge are brought into the fund, ensuring the highest level of industry-related expertise in making strategic fund decisions.
Indeed.
Meeting attendance. Meeting attendance is managed to evaluating the trustee's performance,
Mm-hmm.
time, and involvement. Whilst the level of remuneration should be at the same level amongst the trustee of the same fund, remuneration actually paid the proportional to the time, involvement, and responsibility of each trustee, that a trustee with a greater time involvement is paid more than a trustee with a lesser time involvement.
Okay.
Additional work. Trustees undertaking additional work officially commissioned are remunerated at the approved fund trustee hourly rate, payable to all trustees, which is reviewed by the board from time to time. Travel, accommodation, and other agreed reasonable expenses incurred by trustees. These should be governed by policy, proof of expenditure, and subject to maximum amounts. Disclosure. The annual amount of remuneration paid to each trustee and to whom the remuneration was paid should be disclosed in the annual report.
Okay, so you can see there's a great deal of information in there in terms of how to establish modern pay for the modern trustee. It's very, very detailed and very sophisticated these days compared to what it used to be in the old days when trustees were not paid at all, and then they were paid according to how somebody felt that day and whatever the case might be. Okay, keep going. Finally.
While setting trustee pay follows the non-executive director principles, there is another method that is commonly used. For example, using the hourly rate as set out in the guidelines by the professional body that the trustee may belong to. These rates may vary between
Type of, yeah.
R1000 and R3000 per hour, with an average of R2000 per hour. Alternatively, one would set a combination of retainer and attendance fees paid monthly and on attendance respectively.
Mm-hmm.
Looking forward, we would expect that the role of a trustee becomes more independent in the future as governance requirements strengthen. Coupled with this is the increased skill requirement as the role becomes more onerous and complex.
That word
This,
again.
Yeah.
onerous.
Mm-hmm.
This will have an effect on the practice of paying a trustee, and we expect it would increase both numbers of individuals receiving a payment along with an increase in the quantum of payment.
Quantum meaning amount. Mm-hmm.
The real question would be whether there would be any change in behavior of the person receiving the payment. The consequence may well be that where the organization is investing in an individual, they expect to receive value for the investment.
True or
Thus,
false?
true.
Okay.
Thus, not only would the remuneration become more prevalent, but firmer initial,
Prevalent.
prevalent.
Mm-hmm.
Hold on. Thus, not only would remuneration become more prevalent, but firmer initial competence assessment, performance management, and consequence would result. With this in mind, the overall benefit to the funds would be more valuable contribution by each individual trustee and a more business-like approach to the management of the entity.
Yes.
Ultimately, it doesn't matter which approach is adopted in the setting trustee fees, as long as it is robust, defensible, and supported by market research.
Okay. So again, all of that discussion is just about how to establish fair rates and salaries and so on for trustees in a modern trust society. And also, on the other hand, trying to get trustees to do their part, because some trustees kind of want more and more money, but they don't want to. They want to come and eat caviar, have a ball, and don't do the work. Just leave it with a handful of people as usual. But generally speaking, that kind of gives you hopefully a little more insight than your own notes about the issue of trustee remuneration, especially trustee remuneration in a modern world. All right. We have a few moments. I just want you to see this clip real quick because I don't want to go past 9 o'clock. I don't want to be responsible for anybody's. Otherwise, I'll have to pay the part of the fine. Okay. Let me just see if I can find this real. Let's see, trustee. How much of the trustee? Compensation. Okay, it's just 5 minutes. That's good. All right. There you go. Can you see it?
Yes.
Yeah.
Okay. So this whoever this, you'll see who he is. This is his take on compensation. So now this is only about 3 or 4 minutes, and then we're done. But it's certainly now a real life bit of feedback from somebody who's actually practicing this stuff in the day-to-day world. Okay, let's have a look.
Hello, and welcome back to thelegacylawyer.com. One question I get from people who've been designated as successor trustees to another person's trust or to their parents' trust is, how am I going to get compensated for the risk and the time that I spend as trustee of this trust? Oftentimes, the trust itself won't provide that information. It won't say how much the person should be compensated for their time, although sometimes it will. Sometimes a trust preparer can help the settlors designate how much the trustee should be compensated. It could be a percentage of the trust, or it could be a flat rate on a monthly, bi-monthly, or even weekly fee schedule. But more often, there is no designation. And unless the trust requires that the trustee waive their compensation, they are entitled to reasonable compensation. Now, what is reasonable?
Reasonable compensation again, that word, okay? It's a prevailing word in the trust world when it comes to fees.
Compensation. If the beneficiary requests a review of trustee's compensation, the court will look to several factors to see whether the compensation that the trustee asked for was reasonable. And here are some of the factors that the court looks at. First of all, amount of time spent. Was this a complicated trust? Was this a trust that required a lot of babysitting, hand-holding, a trust that required a lot of work on the part of the trustee? Or was this a small trust, mostly by the book? Secondly, the gross income of the trust. In other words, how much did the trust earn over the time that the trustee was managing it? This is a better guideline for the court than the size of the trust, because a trust can be very large, but not producing a lot of income. Therefore, the trustee did not have to do a lot of extra work for it. Third, appreciation of the trust property. While the trustee was managing the trust, did the trustee grow and appreciate in value? This can be, to some extent, due to the trustee's actions, and therefore should be weighed in valuing the trustee's compensation. Next, did the trustee bring any unusual or special skills? In addition to being trustee, are they also an attorney? Are they an accountant? Are they themselves a private fiduciary? Do they have skills that came to value in their actions as trustee? Next, the level of loyalty or disloyalty to the trust. Did the trustee pass over opportunities because they would be disloyal to the trust if they took them? Or conversely, did the trustee act in such a way that put his interests at odds with those of the trust and the trust beneficiaries? Next, what are the typical fees charged by fiduciaries in the region in which this trust is being administered? So if this trust is being administered in San Diego County in California, the court can look to trust fees for other trusts being charged by private fiduciaries or public fiduciaries. Next, the character of the trust work. Was this a trust which required the trustee to be actively involved in making decisions, or was it more ministerial? And did the trustee rely on outside persons such as CPAs, attorneys, etc., to make financial and other decisions? Finally, the court will look to the trustee's own estimation of the value of their services, because they have a say in what they feel they should be charging. It's not going to get as much weight as some of the other factors, but it is a factor. And the court will listen to what the trustee has to say on that issue. Now, these factors come into play when there is an issue as to compensation. In other words, the trustee will designate an amount that he or she is charging, and that will come to light in an accounting to a beneficiary. And then the beneficiary will have to decide, is this value in the range, or is this something that I should have the court take a look at? Is it worth my time, my hiring an attorney, my paying attorney's fees and court fees to have a court review this charge? That's typically how it plays out. And if you want to know more information.
Okay, so there you go. Somebody out there in the US jungle who's actively involved in trust. And as you can see, the issue of money and fee payment and remuneration is very, very diversified, and the battle rages on. All right, any questions before we break? Great, wonderful. Don't forget, go ahead and finish the
Assessment question?
the assessment questions at the back of each unit that we've done, all 3 of them so far. And when we come next week, we'll go over them quickly first and then move into the next section. Until then, have a great and safe week, and I'll see you guys next week.
All
Okay.
right.
Good
Thank
night.
you.
Take care.
Alrighty.
Oh,